But may I trouble your lordship, Milord, by mentioning one extremely urgent matter. Milord, we are Milord taking out a CAN application today. Milord, we have Milord burnt our midnight oil last night. Milord prepared it, going to affirm it. Milord just now. Milord, may I just indicate the urgency? Milord, we are protected by an order passed by your lordship. I run a restaurant, Milord, on the highway. My lord has Milord directed, Milord, an as interim protection that Milord police should Milord keep a vigil so that private respondents cannot forcibly dispose me. Milord, I was enjoying an interim protection from the civil court also. Now, the plaint has been rejected. We have preferred an appeal. In the appeal, I personally went there, to move the interim application. The respondent, who are the private respondents here, they, prayed for an adjournment. The day, adjournment was prayed, the day, they started, to send goons. We have, videographs,
You go before the court, appeal court.
The appeal
What will police do? I can't pass an order. There is no urgency. So,
may I just indicate, on 20th February, my lord, I indicated, my lord, specifically directed, on an assurance given
order
by
is
the
appeal
police.
to order of the civil court. If a civil court has dismissed your plaint.
No, my lord's order had nothing to do with the civil court's order. My lord, there is no reflection. My lord, that was not the case before your lordship's court, my lord, in the police inaction matter. My lord, that injunction order, my lord, came
There's no
later.
urgency, sir. There's no
My
urgency.
lord, I will be out, my lord, any time.
Every civil court.
When the civil court has expressed its inability, I was there personally, to take up the matter because of the adjournment prayed for, on the personal ground of the lawyer,
ask the civil court to do that, appellate court to do that, how the writ court will do.
Now the plaint is rejected on a technical ground that there is a lease agreement which is unregistered.
What can I do?
Unless I'm protected, at least for a while,
no
I'll be ousted.
No urgency. Maybe consequence of a civil court's order will be like that, sir. Yes, sir.
My lord, item number 347, my lord, on the last occasion yesterday, my lord, my learned senior appeared in this matter, my lord. My lord, he intimated the court that all the accused persons, pursuant to the intervention of this honorable court, surrendered before the learned court below and they got bail, my lord. The purpose of that petition, my lord, has
347. Who is for the state?
My lord, four orders, my lord. State.
Who is for the state?
I'll take. I'll get that.
It is for orders. Somebody else appeared. Bring
Yes,
bring him at 115.
150.
My lord, permission.
Item number 274 of today's list. Yesterday also we had appeared in the matter virtually. The urgency of Reshmi Metallics is starting a factory in Durgapur.
Reshmi Metallics, I will not take up the matter. Where I 274. I'll release the matter. 274. Any into?
I am for the state. In that matter. 274.
My lord, I am mentioning item 226.
Yes. I let the repetition be eased from the list on my personal grounds. Because we placed before the Honorable Chief Justice.
My lord, I am mentioning item 226. My lord, this is a very sensitive matter. My lord, why, my lord, the accused.
These matters were called yesterday. Nobody was there, sir.
My lord,
these matters were called yesterday.
I could not. My lord, the accused is the vice president, all India vice president of Bharat Shivastram.
Let me proceed with 376. I cannot upgrade from here. Yes.
One matter, my lord, under the heading urgent matter. My lord, we recall, my lord.
Where is the urgent matter heading over here, sir?
My lord, no, my lord, I am mentioning the matter. My lord, last day, my lord, Mr. Mukherjee mentioned the matter for leave. Your lordship has, my lord, given the liberty to file and mention. My lord, this matter, my lord, the petitioner brother.
Where is the, have you filed that?
Filed the
number.
Yes, my lord. My lord, the petitioner's brother's body is preserved in, my lord, Purulia district hospital. My lord, we are praying for post-mortem, my lord.
File, give the number, we'll see.
The first call of this my matter.
Filing number
Lordship directed the matter to appeal the monthly.
Take out applications, no more. Order passed. Take out application, I have said that. If order has been passed, that can be recalled only on an application being made, na? You can't do like that. Yes.
I want to mention one application, Lordship, in connection with disposal.
Give it application. Correction, give it. Correction ta kalke diye diyo.
Your Lordship, a matter for upgradation.
Upgradation, not today. Yesterday, yesterday it was called.
Today it is appearing. It was not appearing.
299 is what heading? What? New motion?
It was not appearing yesterday.
Ah.
Today it is appearing for
Hmm.
the first.
Hmm.
Now the difficulty is that out of the civil suit, 227 application referred by the community. And Ashwin,
I'm not hearing the matter. You tell me what is the urgency.
subject by dint of order passed by the 227 court matter, copy served upon the private respondent and the private respondent copy read to the petitioner, and he was forced to leave his house. And now he is not able to.
To ask the 227 court to pass an order. What will,
It's a different issue altogether.
then by using the police you want to dilute the civil court's order. I'm sorry. It will come whenever it will be called whenever usual list. Yes.
Lord, may I be permitted to mention one application for recalling?
Give it.
Uh,
For new application. New application for what?
uh,
New application. I don't have any headings. What do you want to file? Writ application. What is the urgency?
That matter was disposed of. That day,
So be prepared. I can't wait like that. Be prepared and come. List call karo.
Number one.
Learned advocate appearing. You are the advocate on record. Junior of the advocate on record. Have you got written instruction? Give that. Learned advocate appearing for the petitioner do not intend to proceed with the present writ petition to that effect. Written instructions have been submitted accordingly. WPA 17079 oblique 2024 is dismissed as not pressed. Next. Written instruction submitted, be kept with the recorder. Next.
Well, I'm for the petition.
Pardon.
Just pending for a report.
I've been told that I have the report, my lord. Unfortunately, it's with my junior, my lord. Investigation is on, my lord. Charge sheet has not been submitted.
Why?
Well, that is what the report is, my lord.
Let me see.
My lord, I don't have the report at present, my lord. Junior has it, my lord.
Produce the case diary. What are you doing? I'll check up.
My lord.
List the learned advocate aid appearing for the state submit aids that the investigation of the case is still in progress. Records reflect that the case was initiated in the year 2023. Let the case diary be produced before the court. List the writ petition under the heading for orders in the monthly list of August 2025. Next.
My lord, I am for the private respondent in this matter.
I am for the state respondent.
You are the petitioner. You got where? On the record. Written instructions কোথায় আছে? Written instruction দিয়ে দিয়েছে বলছে already on record.
My lord, the dispute has already been amicably settled outside the court.
এগুলো এখানে এই ইনক্লোজ করে দিয়েছি, সব জানে না এইটা এইখান থেকে এটা খুলে নেবেন, খুলে নিয়ে এটা ভালো করে এটা রেকর্ড লার্নের বুঝতে পারছেন সেকেন্ড পেজটা learned advocate aid appearing for the petitioner submit aids that he has necessary instructions not to proceed with the present writ petition. Accordingly, WPA 11648 of 2025 is dismissed as not pressed. Written instructions submitted be kept with the record.
I'm grateful to your lordships.
Next. For 12 বাজে নেই তো।
Order, item number 301.
Mukherjee is appearing in this matter. As advocate on record is Supreme Court matter. So that is the
So monthly list of August, learned advocate appearing for the petitioner prays for an accommodation on personal grounds. List the writ petition in the monthly list of August 2025 under the same heading. Next.
My lord, 302, the advocate Somnath Ganguly. He is engaged in court.
Petitioner nahi to eta ke?
Courtroom number?
None appears on behalf of the petitioner.
Somnath Ganguly.
State also, learned advocate for the state also prays for an accommodation. The learned advocate for the petitioner is present kore dao aur ye state prays for an accommodation. Months of August, sir, I can't do anything. Repeatedly, same matters are being called. No, I know, I remember. I gave return the case diary and asked them to restructure it. Months of August, it will appear under 4 orders. Regularly, same matters are being called.
Lordship, Shumon Ghosh is in this matter. I pray for not this week.
This matter I am appearing, Lord.
Which one?
This actually in this matter there is nothing.
Learned advocate appears for the Ames Kalyani and hands over the report. Where is the petitioner? Yes, that Ames Kalyani matter, na? Where is the petitioner?
Lordship, for the state, Shumon Ghosh to appear for the state.
What is it?
This is the primary finding of the court after counsel of
They are satisfied with the state, the medical report of the state, basically.
yes, that there are no signs of successive of sexual assault. This is the case. And pursuant to your lordship's direction, the board was formed.
So where is the petitioner? Why are they there? File করে দিয়ে চলে যায় যেন তাই এটা চলে আসুন এই ডিসপোজ অফ করে দিয়ে কিছু বাকি রেখে লাভ নেই হ্যাঁ আর কোনো প্রেয়ার আছে কি এদের নাকি দিতে লোকের ক্ষতি হয়ে যায় কেউ দায়িত্ব নেয় না এটা সব একটা করে ফাইল করে দিই প্লিজ ট্রান্সফার ইনভেস্টিগেশন প্রেয়ার অলসো লোকে আসবে না মামলা ফাইল আচ্ছা Mr. Mojumdar Earl and DSGI appearing on behalf of Ames Kalyani submits that earlier our direction was earlier the report has already been submitted before this court prima facie on assessment end of the documents which were placed before the board. The board arrived at its conclusion that there were no signs suggestive of sexual assault. Inverted মধ্যে দিয়ে দেবে হ্যাঁ হ্যাঁ there are so far as the role of Ames Kalyani is concerned further directions are unwarranted. As such, Mr. Mojumdar Lane DSGI is recused from the case.
I'm for the petition.
So I'm keeping it for hearing. You want transfer to? You want transfer of investigation to? I'm keeping the matter for hearing, sir. So far as the Ames Kalyani has concurred with the opinion of this Murshidabad hospital.
Report.
Yes.
But yes, Milord, I think Milord has sent the matter for histopathological. Yes, that is there. We have done everything. Histopathological report, Milord, that is not supposed to come anything because there is no
whatever it is, it has been done. There is no they have come to an opinion that there was no sexual assault. So you do the hearing for transfer of investigation. I am not disposing of the matter. I am not disposing of the matter basically.
So, Milord, is for epidemic.
Whatever the state will do, whoever gives, because I am recusing them. Ames Kalyani is no further required. Their function is complete right now. So far as affidavits are concerned, you exchange the affidavit.
Short date because Milord,
No short date. Half of the days you don't work. Yesterday, why didn't you come, sir? Yesterday, why didn't you come? The roads were clear and clean. They came. No, they means what, sir? The roads were, you can't blame anybody.
blaming anybody.
No, but the habit of making urgent prayers over here and not doing work regularly, this is creating hardship on the court. No.
All days I was there, Milord.
Huh?
All days, Milord. Almost all days, Milord. I mean, only one day yesterday, last day. Just a simple prayer.
I'm keeping, let them fight. Acha, file affidavit in opposition, sir. is as such recused from further appearing in his case. In this, if the petitioner has also advanced prayers for or transfer of investigation, having considered the same, the respondents are directed to file their affidavit in opposition, preferably by 18th of August. Na, কত হলো? 21st, এক মাস টাইম নেই। আজ 22 তো হ্যাঁ, by 21st of August 2025 ইয়ে হলো affidavit in reply. How much time will take? By 29th of August 2025 list the writ petition under the hearing in the month list of September 2025. State would submit a progress report on the date fixed for hearing. No more forwarders.
Otherwise, it will not. It will.
Do before other bench. There are other bench also. Do before other bench. There are other benches also. আরেকটা দিকে দাও। 5 নম্বর তো হয়ে যায়।
Number 304.
আছে কি?
304.
Yes.
My lord, I am for this
Right,
case,
yes,
my lord.
Uh-huh.
My lord, I beg to appear for the petitioner. My lord.
Yes.
Lord, on the
Motion
last
to ready
occasion, my lord, first give a direction to hand over the case diary. The same has been returned and again.
No, already lying there.
Huh? Ki?
এই এটাকে বেঁধে দিয়েছে তাই বার করো তো। কেস ডায়েরিটা বেঁধে দিয়েছে তো বার করো।
কি মামলা?
সব ছেড়ে যাবে, আস্তে আস্তে করো, আস্তে আস্তে করো, আস্তে আস্তে করো, আস্তে নাও।
সরিয়ে রাখবো। হ্যাঁ, কমপ্লিট করে দিলাম।
মোটাটা দাও, তারপর তুমি গুছো। কেস ডায়েরিটা দাও।
এই তো
এবার দেখো।
আরে তোমাকে দেখলেই আমি জয়েন হবো। করে তাই করে নিয়েছি পড়াশোনা করে। নাসির
মোশন 2টা রেডি করো।
করে দিয়েছো তাই তো?
You got a case diary?
My lord.
What did you do in further investigation?
My lord, first of all, you go to look into page number 17.
17, no, 70.
17. This one is the injury report.
No, I'm not into the merits of the case. Further investigation, what have you done? I can decide a case. Suppose I'm not supposed to interfere to that extent. Writ court supervisory jurisdiction. You are carrying on a further investigation. Is it further required or not required? Tell me.
Not required, my lord.
Not the. Have you closed the further investigation?
My lord.
Have you closed the further investigation?
I have already submitted the final report. My lord.
Final report.
My lord.
Where is that?
I have no intimation in this regard.
না এটা না এটা না না এতে নেই রিপোর্টটাতে দেখো My lord, it's not submitted, but supposed to be submitted, my lord.
To see that, because the document which you have submitted before me, it is last of the date is of 24th of February 2025, when you have worked on in the month of February.
My lord.
So I just want to check the part of further investigation what you have done. You only give that. Earlier there was direction for further investigation. That means magistrate was not satisfied with your investigation. So the part which you have done only at the time of further investigation. I don't think you have done except to the extent. If you come to page 425. 425, you see that they were, according to you, have you got that?
My lord.
You see over here, you have recorded resumed further investigation of the case. All right, starting line. Then you come that death was due to electrocution. Second last line or third last line? Have you got the term electrocution?
My lord.
Now, next sentence you write, however, meticulous investigation and circumstantial evidence is necessary to establish the cause of death. This is what you have written in, this is your document, the investigating officer's document. As such, what remains is that to check only that if you have come to an opinion regarding final report, give what you have done. This you have recorded, sir. I have not recorded that.
My lord, most probably I have submitted this case diary before 3 or 4 months back to you.
So you take back this, you give whatever they have done, show me, I will just...
What is the current status? You fix a time for it, my lord. Otherwise, it will take again 2 or 3 months, my lord.
No, I will not say. Current status, you submit, next week you submit, I'm keeping this.
Once again next week, tomorrow, my lord. Any time, as per your choice.
Not today, tomorrow, come back, sir. I'm just recording. I have got no issues, sir.
But I just one thing.
I have no issues. I will check what you have done. Sir, in a 220.
I will submit a fresh report. What I have done.
Report I don't require. What case diary I require.
My lord.
Next week চলে আসুন হবে না আর কিছু হবে না এখন কিছু নেই
Nothing has been done.
So let them show me.
Execution has been take place. An unnatural death, body has been buried.
Case diary be returned to Mr. Shahi. You keep this. One case diary you keep. Both you don't have to keep. Case diary be returned to Mr. Shahi, advocate appearing on behalf of the state. So far as the issue relating to further investigation is concerned, learned aid advocate for the state submits that the investigating officer is at the verge of arriving at his conclusion. Be that as it may, the case diary be produced reflecting the stages which have been in steps which have been taken by the investigating officer of the case. List the repetition under the same heading. On 29th of July 2025. Come tomorrow. Next week, this day. For orders. Case diary return করে দিন. Fresh case diary.
But I don't even know what investigation they have done, and right now they are turned up with the final report.
Case diary be produced. And for orders এই আসবে.
Lord, only one thing. On the last occasion, I was appeared virtually, my lord. Report has been submitted.
কিছু report case.
Can I have that, my lord?
Let me go through the case. I'll give you everything. Motion to. আমার পাগল করে ছেড়ে 11:12, sir. Tomorrow I'll take up. No issue. Tomorrow I've given the timelines in my
monthly 814 out of the month.
এটা ঠিক করে দিন 814 কেউ অ্যাপিয়ার করবে না কিছু করবে না মামলাগুলো লিস্টে মেনশন করে দিন Adita or in the nature of mandamus to issue commanding the respondent to show cause as to by the respondent. So it will take experience. Anybody appearing for the state in this matter? Petitioner approach the AA's court. Any junior members? Mr. Petitioner approach the AA's court. Being aggrieved by the progress of investigation. The case number দেয়নি কিছু দেয়নি কি বলবো being aggrieved by the investigation হবে না কিছু নেই এর মধ্যে লেখেই নি কিছু being aggrieved by the steps taken by the officer in charge Ilambaj police station pursuant to the information furnished on or about 20th March 2024 20/3/2024 আচ্ছা as none appears on behalf of the state
Neelam Singh.
আচ্ছা Mrs. Neelam Singh learned advocate is directed to represent the state her appearance will be regularized by the concerned authorities having regard to the time period which has lapsed in the meantime. I direct the petitioner that in case in case she is aggrieved she would file a fresh representation before the officer in charge of Ilambaj police station. Acha, if no steps are subsequently taken by the officer in charge, officer in charge, the petitioner would be at liberty to approach the jurisdictional magistrate in respect of the release aid for. The learned magistrate would assess regarding the correctness of the accusation and thereafter pass necessary directions as it deems fit and proper. With the aforesaid observations, WPA 9981 of 2024 is disposed of. Server copy next.
नाम दिए दिए थे.
But I'm for the petitioner.
Yes.
But the petitioner is the owner of the land. But I have annexed the record of rights on 9. Petitioner was ousted from the land to the petitioner. But petitioner made representation page 22.
Yes.
And thereafter complaint was made to the police authorities, but no steps have been taken by the police.
Please, somebody appear for the statement. Learned advocate appearing for the petitioner is agreed by the fact that he has although he is agreed by the fact that although he is submitted a written information on or about 20th March 2024
that a copy দেবেন না
before the superintendent of police Singur district 8 Hooghly. No steps were taken by the aid office and consequently and the petitioner complains that he has been ousted from his property. As none appears on behalf of the state, Mrs. Chakraborty, learned advocate who ordinarily appears on behalf of the state, is directed to represent the state. Her appearance will be regularized by the concerned authorities. Full stop. Having considered the plight expressed by the petitioner, I am of the opinion that if the petitioner has been ousted from his property, so far as restoration of the possession is concerned, petitioner would approach the jurisdictional civil court. However, the police authorities would monitor that there should not be any breach of the peace or tranquility and or any untoward incident because of the strained relationship existing between the petitioner and the private respondents. With the aforesaid observations, WPA 9984 of 2024 is disposed of. Server. Cannot decide that. Cannot decide that, sir. Got to go to the civil court, sir.
Affidavit of service.
Affidavit of service file be kept in the record.
116.
এই দেখি কপিটা দেখি কপিটা
16 my lord, appearing on behalf of the state respondent.
You have got a report?
Not yet, my lord. It's a direction by the SDO to take care, and also respondent number 5 has a direction to inspect the matter. Nobody appearing in the petition.
Is there a direction upon the police authorities?
Yes, my lord. Respondent number 5. When I am led by Mrs. Ipsita Banerjee.
This service to be there. What is the direction upon the inspector is directed to keep vigil on the
upon the Khatra PS, my lord. Not yet.
So what is the grievance of the petitioner?
Grievance of the petitioner.
Yes, he approached.
Taking care of the mother.
No, that's a
against the son and daughter-in-law.
For that proceedings have been advance before the SDO.
SDO has a specific direction upon the respondent number 5.
So, petitioner has approached this court being agreed by the fact that in spite of directions passed upon the inspector in charge Calcutta police station for maintaining peace and tranquility and for keeping and also keeping a strict vigil, the police authority is failed to adhere to such directions. Full stop. Records reflect that the petitioner is a senior citizen who approached the SDO by way of invoking maintenance case number 01/M dash SDO K capital K bracketed oblique 2023, having considered the directions passed by the subdivisional officer Khatra Bakuda under the relevant provisions of the Maintenance and Welfare of Parents and Senior Citizens Act 2025. I direct that in case further directions are passed by the SDO Khatra Bakuda, the police authorities would respect, obey, and implement the said order in accordance with the directions so passed, as also in consonance with the provisions of the Act. We therefore said
The petitioner doesn't appear, my lord. Petitioner is
what
not.
can be done?
Okay.
WPA 10048 of 2024 is disposed of. Server copies. Chalo. Next is
817.
My lord, I am appearing on behalf of state. By mistake, group 2 matter. By mistake appear in the list 817, my lord. Group 2 matter. Sagat Bhattacharya.
Group 2. Forme ki ligation. Second is it is secondary school education লিখছি এখানে
0189 WPA 10189.
আমি প্রেয়ারটা দেখে নি the school education. It has been pointed out that the nature of grievance required to be addressed in the writ petition do not fall within the classification
Liberty to mention as the order.
or fall within the classification assigned into the AA's code. Accordingly, WPA 10189 of 2024 may go out of list. Liberty is granted to the parties to mention the writ petition before the court having determination. Next.
I am for the state. I am submitting the report. This is a purely civil dispute, my lord. The private respondent, I got it from the report. The private page 2, my lord. Private respondent herein has been residing in the disputed land for the last 30 to 32 years. My lord, the case and counter case has been filed. The charge sheet has already been submitted, my lord. On page 2 of the report.
Records of the writ petition reflect that the petitioner approached this court for initiation of proceedings on the basis of the information furnished on 30th January 2024. It has submitted a report. Report reflects that there is a long-standing land dispute already existing between the petitioner and the private respondents. The report also reflects that on the basis of the information furnished on behalf of the petitioner and or his associate. Bhatpada PS case number 879/23 he was registered for investigation, and on conclusion of investigation, charge sheet has been submitted before the jurisdictional court. It is also reflected in the report that Bhatpada case number 992/2023 was registered pursuant to the information furnished by one Rinku Das, and the said case was against the petitioner and he and or his associates. Yellow. So it is also reflected that charge sheet has been submitted in connection with the say 8 case. Having considered that police authorities also at the relevant point of time has drawn up proceedings under section 107/160 of the CRPC. Having in regard to the fact that a long-standing land dispute is existing between the petitioner and the private respondents, and the records reflect that number of criminal cases or and counter cases have been are pending before the jurisdictional court. I am of the opinion that in case the petitioner is faced with some inconveniences for which the police authority did not act, petitioner will approach the jurisdictional magistrate for appropriate remedy. Full stop. No further interference is called for at this belated stage. Accordingly, WPA 10334/2024 is disposed of. Reports are submitted. Be kept with the record. Several copies.
19, I beg to appear on behalf of the state.
I have the instruction to appear for the respondent number 6.
Well, I am for the respondent number 5.
Petitioner, who is petitioner?
This is the number of writ petition this person has filed so far.
Maybe. No, you are occupying the petitioner's position, sir.
Petitioner is not appearing at least 2
Yes.
Your Lordship kindly sees the CCTV is not, my lord.
Pending application when is disposed of.
That
Thank
was
you.
not privacy, my lord. It's outside the wall, my lord.
কি আছে কি?
CCTV.
হ্যাঁ?
Tenancy dispute.
Mr. Karan, কি আছে দেখি না?
Hello,
Any report?
yes, I have a report, my lord.
I'll give it.
But before I place the report, my lord, may I, my lord, it's a two-storied building shared by two co-sharers, my lord, and one of the co-sharers lady, my lord, she fixed 3 CCTV cameras, one in the terrace, one in the, my lord, outer wall, and another in the staircase, my lord. This is the, my lord, picture of the where the CCTV cameras have been installed. My lord, it is no way, my lord, hampering the privacy.
This has got nothing to do. এই তো বাংলা কথা চলে এসেছে। Learned advocate, আচ্ছা না, the records of the writ petition reflect that an information was furnished by the petitioner to the Commissioner of Police, Calcutta, as well as the officer in charge of Shampur Police Station. Acha. It is the contents of such information reflects that 2 CCTV cameras were installed inside the house and within the territory of the petitioner. Petitioner claims that such CCTV cameras had been installed for intruding in her privacy, and accordingly informed the police authorities, but the police authorities did not respond to the same. Achha, Mr. Karan Landed advocate appearing for the state has submitted a report. The report reflects that the petitioner has already filed a title suit being 464/2022.
2 title suits are there, my lord.
Before the Learned City Civil Court at Calcutta. Subsequently, another suit would be in
472.
472/2022 has been initiated. since the civil court is already in CCE in of the issue, it would be it would be for the petitioner to approach the civil court to establish that her privacy is being intruded, as the report submitted by the police authority is reflect that a dispute is already existing between the petitioner and the private respondents over a property. Full stop. In case the civil court on an appropriate application preferred by the petitioner.
Not only one in this, these are not the issues in the civil suit pending, will it?
They can take out, sir. Whatever the issues are for a
But
civil.
the issues pertains to the tenancy given and the partition of the property.
So the tenancy agreement, if CCTV is application is made, the court can obviously decide that this is not for me to decide this. Cholam. Preferred by the petitioner is of the opinion that the privacy of the petitioner is included, then in that case appropriate directions be passed by the civil court. Full stop. If the civil court thereafter is of the opinion that police assistance is required, necessary directions be passed upon the police authorities. When the police authority would respect and obey such order. So, in regard to the time period which has lapsed in the meantime, I am of the opinion that at the is stage, without any evidence, it would be difficult for the court to summarily arrive and adjudicate the dispute canvassed before this court. Accordingly, WPA 100345 of 2024 is disposed of. Reports are submitted. We kept it as a server copy.
May I give a
Virat report. Copy of the report be handed over to both the bodies.
Hearing to all the participants.
তাই করে সিভিল কোর্টটা কি করে হ্যাঁ কি আছে Yes, Mr. Singh, you are there.
State, my lord. I've got a report, my lord.
আচ্ছা কি আমার ভিতর নিয়ে দেখাতো
Taken the cultivation land, my lord. Petitioner report says on the third paragraph, my lord, the report that the petitioner father sold out the particular land to the respondent number 6.
Records of the case reflect that an information was furnished with the officer in charge of Nolhati police station to the effect that the respondents had harvested the crops of the present petitioner, which resulted in a loss of rupees 60,000. Full stop. Learned advocate for the state has submitted a report.
And subsequently, my lord, paragraph, my lord, third paragraph of the first page, my lord.
Yes. Report reflects that a civil suit is pending between the parties, being title suit number 194 of the 2022. Full stops. Another miscase was having regard to the fact that the civil court is already in of the issue 141. Having regard to the fact that the civil court is already in CCA of the issue. So far as right, title, possession, and interest is concerned, it would be the civil court to adjudicate the same. This court, while exercising its powers under Article 226, will not enter into a dispute, will not enter into issues relating to private dispute. Accordingly, WPA Auto 10447 of 2024 is disposed of. Report submitted. We kept with the record. Server copies next.
821. 21, 821, my lord, I take to appear.
Yes, appear. What is the prayer?
The prayer, you lordship kindly see, this is a petitioners are the joint borgaders of 81 decimals of land. He claims that the private respondents are trying to oust him from his Borga property, my lord, and they are trying to make a brick field there, my lord. Police, there is a long pending dispute regarding this, my lord, police has taken step and started 107 for maintaining peace, my lord.
You got a report?
Yes, my lord.
The present petition has been preferred, being agree by the inaction of the police authority is as the officer in charge, Murarisha outpost under Hasnabad police station refused to take any action. The main grievance of the petitioner is that the petitioner happens to be a sharecropper. Who is attempted to be illegally and forcibly disturbed in enjoying the property at the behest of the private respondents. State has submitted Mr. Karan Lane, advocate appearing for the state, has submitted a report. Report reflects that an absolutely private dispute is being given the cloak of given the cloak for calling for interference by the police authorities, although the police authorities have hardly any role to decide the issues.
Para 8 of my report.
I find that the police authorities apprehending breach of the peace and tranquility at the relevant point of time to a proceedings under section 107 of the Code of Criminal Procedure. Having considered the steps taken at the relevant point of time, I am of the view that for establishment of right, the petitioner has to approach the civil court. Police authority is in consonance with the provisions overseeing the law and order crisis. Full stop. They would continue their surveillance if they the police authorities would continue their surveillance in case they are of the opinion that there is possibility of any untoward incident taking place. With the aforesaid observation, WPE number 10859 of 2024 is disposed of. Report submitted. We kept the record server police.
322.
In this matter, I am appealing to state, my lord.
Yes.
My lord, submitted before SC.
This matter, I am appearing on behalf of the petitioner.
Petitioner.
May I permitted to file my affidavit of service?
My
lord, on 14/11/23, the respondent number 4 and 5, my lord, forcibly entered the house of your petitioner and started assaulting her as the husband to sign some blank paper to sell the property, and he refused. Thereafter, he was brutally beaten up, and not only that, my lord, the petitioner also assaulted. Your lordship, kindly come.
The FIR has been registered. What are you wanting?
My lord, the police authority already unholy nexus with the respondent number 14 and 15. They already started the case, my lord, in spite of the court's order. Bailable section, my lord. All the non-bailable sections.
Charge sheet submitted. Go before the jurisdictional
I have
court.
heard. Verbally, I have received.
Charge sheet submitted.
Still started.
Petitioner approached the court as she was aggrieved by the action of the police authorities, particularly with regard to the fact that in spite of Modumgam PS case number 40/24 dated 21/1/2024 being registered for investigation, but the sections under which the case was registered was in respect of diluted sections which paved the way for bail and other remedy is being available under the law to the accused persons. Full stop. Learned advocate 8 for the private respondent numbers
4 and 5.
4 and 5 submit that there has been complete change of circumstances is, and the trial of the case is in progress. On instructions করে দেবে, হ্যাঁ? আচ্ছা, state has submitted a report reflects that Modhungram PAS case number 40/24 dated 8/21/2024 on conclusion of investigation resulted in submission of charge sheet before the jurisdictional court. Records also reflect that charge sheet was submitted under sections 448, 323, 325, 506, 34 of the Indian Penal Code. Full stop. Since a charge sheet has already been submitted before the jurisdictional court, petitioner has statutory remedy is for canvassing the grievance. As such, no interference is called for by this court at this stage of the case. As such, the petitioner would be at liberty to approach the learned magistrate under the relevant provisions of law. With the aforesaid observations, WPA 11053 of 2024 is disposed of. Report submitted. We kept with the records. Our chalo. Next.
I am appearing on behalf of the petitioner, my lord. My lord.
Thereafter, yes. Your
respondent number 6, 7, and 8.
My lord, that the land
disturbance.
Yes.
Only. Petitioner is aggrieved by the act that you are the private respondent.
No.
Are Baba. What are you doing? Disturbing him? Why?
Nothing
ঠিক আছে, হ্যাঁ।
Let them file civil case.
Learned advocate appearing for the petitioner submits that the private respondents are unnecessarily interfering and disturbing the peaceful enjoyment and possession of the property of the petitioner. And to that effect, in spite of informing the police authorities, no effective steps were taken, for which the private respondents continued their illegal activity. Full stop. Learned advocate for the private respondents disputes and denies such contentions and submits that denies and disputes such contentions and submits that a civil dispute has been given the cloak of police inaction.
Private respondent is not the owner of the land.
এই তো মুশকিল, ইউ ক্যান সে স্যার, এই সবাই এসে বলে ওনার, আমার কিছু করার নেই এটা। আচ্ছা, state has submitted a report. ঠিক আছে, that the civil court will not see. Say it has submitted a report. Report reflects that at the relevant end point of time, since there was a dispute between the petitioner and the private aid respondent, appropriate proceedings were drawn up, and the police authority is ensured that there is no breach of the peace and tranquility. Full stop. Prima facie, it reflects that there is a dispute and difference between the petitioner and the private respondents. Consequently, if further inconvenience is faced, petitioner would be at liberty to inform the police authority, who would take steps in accordance with law. With the aforesaid observations, WPA 11062 of 2024 is disposed of. Reports are submitted. We kept the records. Our copies next.
The prayer was to register the case, and the police registered the case. Private parties also filed their complaint. Lordship, his application is all complaint is also registered and also charge sheeted. Both the cases charge sheeted.
Acha. Records reflect that the petitioner approached the court as there was inaction in respect of the complaint dated 30th March 2024. Full stop. Mr. Yusuf Lane, additional government leader appearing on behalf of the state, has submitted a report. Report reflects that কত ডেটে কমপ্লেনটা বললাম? 30th March না? আচ্ছা, report submitted by the state reflects that Pornosi PS case number 224 dated 14/4/2024 was registered for investigation.
Last page, Your Lordship.
Report also reflects that there was a transaction which had taken place between the petitioner and the private respondent. Hasham. At the behest of the private respondent number 7, another case was registered being pornography PS case number 243 dated 24/4/2023. Since the primary grievance of the petitioner relating to police authority is not acting, and the records reflecting that on the basis of the written complaint of the petitioner, case has already been registered against the private respondents. I am of the view further interference in respect of the prayers advanced before this court are unwarranted. Petitioner would be at liberty to take further steps before the jurisdictional court.
Both the cases, Lord, charge sheet filed, Your Lordship. Both the cases. Last page, Your Lordship.
আচ্ছা একটা লাইন লিখে দিন ভেতরে, ওইখানটা রেখে দিন, নিয়ে তার আগে লিখে দিন। আচ্ছা, ইন রেসপেক্ট অফ বোথ দ্য it is reflected in both the criminal cases referred to above. Charge sheet, on conclusion of investigation, charge sheet has been submitted before the jurisdictional court. তারপরে কি বলছিলাম, যেখানে লিখছিলেন আপনি? আচ্ছা, ওইখানটা as a jurisdictional criminal court is already insisting of the criminal cases, petitioner would be at liberty to take appropriate steps before the jurisdictional court insisting in of the criminal cases. With the aforesaid observations, WPA 1128 of 2024 is disposed of. Report submitted. We kept with the record. Several copies next.
Private respondents were directed, listed from our even they are coming, they are in the power they have,
which
they are entering the prompt, taking away the prompt, and despite information to the concerned administrator, but no action has
No action taken. Which police station? Kishno Dupulia কি হচ্ছে? Yes, Mr. Mondol.
No, I am appealing for the private respondent.
Yes. Injunction order challenged.
My lord, to my instruction, there is no such appeal.
So you were supposed to appeal.
Yes, my lord. There is no instruction regarding appeal, my lord.
It is also reason came to know that over the same fact to petition receive on gallo. I hear very strange.
My lord, injunction was made absolute as per page 23.
We have informed the opposite party regarding this court order.
If there is any violation,
learned advocate appealing for the petitioner submit that in spite of directions being made absolute in connection with the title suit number
385 of 2021.
385 of 2021. The private respondents had been interfering with the peaceful enjoyment of the property, and it is further submitted that the petitioner, being an octogenarian, is facing insecurity because of the aggression and adamant attitude of the private respondent. Full stop. Adamant attitude of the private respondents. Full stop. There are also allegations of the harvested crops being taken away, as well as changing the nature and character of the property. Learned advocate Acham. Learned advocate 8 for the state has submitted a report. The report reflects that till date there has been no change of nature and character of the property. However, as a petitioner is a sharecropper and there is a direction from the civil court, I am of the view that police authority is would ensure that the order of the civil court until and unless it is altered by a higher forum is respected and obeyed. At the relevant point of time when there was a dispute, police authorities have drawn up proceedings under section 107, 116 of the CRPC. Police authority would continue the surveillance if required. Full stop. The report lastly submitted was of a report. The information which was lastly submitted with the police authorities was on 30th March 2024. If the petitioner is faced with fresh inconveniences, he would inform the police station. Police authority would oversee that the civil court's order is not violated by any of the parties. Full stop. We therefore say a observation WPA 11285 of 2024 is disposed of. Reports are submitted. We kept with the record server copies. So, a copy of the report we handed to both the parties. Sharecropper, Borgata, sharecropper. Yes, who is appearing? Asha. The writ petition was preferred as the officer in charge, Junpur Police Station, did not respond to the information unfurnished. On 23rd of March 2024. Good stuff. Acha. Acha. The main grievance of the petitioner, as was furnished by way of a written information, was to the FAA that the petitioner was not allowed for a peaceful cultivation as well as harvesting paddy in respect of the land, and as such directed the police authorities to take appropriate steps against the private respondents. Full stop. Who will appear? As man appears on behalf of the state. Your good name, madam? Learned advocate. When Mrs. Sonima Sengupta is directed to represent the state, her appearance may be regularized by the concerned authorities. Yellow. Acha. Having considered the nature of the dispute complaint to the police authorities, I am of the view that the police authorities would only oversee that no untoward incident results because of the inimical relationship existing between the petitioner and the private respondents. Full stop. We therefore said observations. WPA 11425 11425 of 2024.
The private respondent.
Learned advocate. Give the name. Learned advocate for the private respondents are present and disputes and denies the contentions made by the petitioner. Chalo next.
827.
826 or 827?
27, man.
27.
Follow the list.
27, I am appearing on behalf of petition.
Yes, you appear.
Lord, affidavit of service, my lord.
Very good.
My lord.
Yes, what is your...
The private respondents are connected with the political party, and they are trying to grab the petitioner's land and forcefully entered on
Trying.
Since then and on 6th
Case has been registered though.
20, I have stated, my lord, paragraph 6, my lord, page 5.
16, my lord.
My lord, case has been started on basis of my complaint that they vandalized and they assaulted petitioner and petitioner's family members, and case started on Khejuri police station, case number
Yes,
381.
yes,
After
yes,
that counter
Private respondent 4 and 11, my lord, permanently
is that
residing at Odisha, my lord.
I am not entered into my house, and I and my family members totally homeless, my lord. I have stated in paragraph 14, my lord.
That you have
that
stated.
they are all by state of the private
Petitioner is
respondent.
agreed by the fact that there has been there has been interference with the peaceful enjoyment of the property of the petitioner and to the effect
phone number
allegations have been made against the private respondents. Records reflect that a case has already been registered with Khejuri case number 381 dated 6/6/2023. Having considered that the police authorities have already taken steps in respect of the complaint so made and no information has been furnished to this court regarding the further progress of the investigation. I'm of the view that at this belated age stage, it may not be fit and proper to pass necessary directions. There is a specific directions. Also, learned advocate for the private respondent and submitting the respondent numbers 4 and 11 are staying at a different state. In spite of the same, they have been implicated in a criminal case. Who is for the state? Hey, Mr. Shengupto. Huh? Earlier matter you appeared. All the matters you will appear. Huh? $826, your name has been incorporated. Okay. 820. Number is just 1 minute later, you appeared. What is your name? You appeared in few matters back. Name has been incorporated.
Appearing for 26.
Tonima Shengupto name has already gone in one of the matters. Let all of the junior members of the bar appear.
320 there,
Tonima Shengupto name has already gone. 826. Your name is what, madam? What is your name? Teen naam to jayeni. Tonima Shengupta has gone in the earlier matter. You appearing. এই মুশকিল হয়ে যাচ্ছে কিন্তু অ্যাপে এই মুশকিল হয়ে যায় আমাদের লোককে সাহায্য করতে গিয়ে বিপদ হয়ে যাবে হ্যাঁ না না ওটা ওইটাই রেখে দিন ইউর নেম কোনটায় কত নম্বরে আছে বলুন তো Tonima Sengupta 826 you give your name Tonima Sengupta your name is Vinita Bhattacharya in this matter all right 27
is court being aggrieved by the inaction of the police authority.
Paragraph 8 at page 3.
Wait 1 minute. Is representation টা দেখে নি কোথায় দিয়েছে না দেয়নি?
Lordship, they have read the page 19, Lordship. 18, Lordship.
Being aggrieved that the representation advance to the officer in charge Domju police station was not acted upon petitioner is aggrieved in respect of the act in respect of the acts and actions of the police authorities as construction was being
The parties living in the
progress.
same plot as
Construction was being progressed by forceful and illegal means without obtaining any no objection from the fire department. State has submitted a report reflects that a title suit number 644 of 2023 was pending against the present petitioner. The police authority is aware regarding the dispute over the construction. At the relevant point of time, police authorities also kept a strict vigil so that no untoward incident resulted. Having considered that the police authorities were well aware in respect of the nature of dispute amongst the petitioner and the private respondents, I am of the opinion that in case any of the party is faced with fresh inconveniences, they would approach the police authorities who would act strictly in accordance with law.
And this is also pending, Your Lordship.
I have recorded that. With the aforesaid observations, WPA 11603 of 2024 is disposed of. Report submitted. Be kept with the record. Server official.
I'm for the petitioner. Petitioner is a bona fide tenant declared by the competent civil court. Lordship, the petitioner being a tenant was not provided with electricity. He got an electricity connection, but the private respondent being the landlord is not allowing the connection from the meter board to the shop room. Lordship, we have approached the
electricity will go to the
no, I have already got the electricity connection. Now from the meter board,
the execution will be by the other court having determinations. That you will not decide, the court will decide, sir. You require police help for that. That is what you are wanting.
You want the police help so that the electric
go to that court. How a court will implement electricity means.
No, Lordship will kindly consider. I have got the new electricity meter board.
No, I am very tough nut. I can't understand, sir. Go before a better court who will understand this. যেটা বলছি সেটা শুনছে না the since the classification under group 9 has been differently has been segregated, let the writ petition go out of list. The writ petition be listed before the court having determination to take up electricity matters under group 9 though na একটা group 9 electricity matters.
Yes.
Electricity matters under group 9. চলো তারপর কপি করুন কি আছে
But I'm for the private respondents.
Lordship, I'm for the state, Lordship.
This is third read on the same.
Baba, third read.
Kindly see two or
How many times you appeared?
My lord.
How many times you appeared?
But I appeared.
অনেকদিন ধরে চলছে primary allegations are against the কি হয়েছে কি করেছে
Lordship, can you see the report, Lordship?
Earlier
Page 2,
videograph-
para 2, Lordship. Civil lit petition is issued on the same issue, Lordship.
And earlier from court WhatsApp call.
This person is the reason of Mirabasu.
And lady has denied.
On which Mirabasu it has sister Joyita Pal, but she denied to meet. The incident happening that time the whole incident was before the Honorable Justice Joy Shenu to the police over the same issue.
This is third read.
Yala.
In 22, in 23, this is 24.
Lady suffering of multifarious old age ailments and illness.
Can you see page 23, the last order? 23, man. Detailed report was called for, videography was done, even WhatsApp call was made from the court to see whether lady is in need of meeting this particular petition or not.
Acha, the writ petition. Yeah, the records of the writ petition reflect that earlier the writ petition appeared on 5/9/2024 before a coordinate bench. এটা তো রিলিজ করেছে, অ্যাসাইন করেছে, এরভাবে চলে এলো কি করে? অ্যাসাইন করেছে, এটা রিলিজ তো অ্যাসাইন করতে হবে তো। ওটা দেখো, যে যার মতো ঢুকিয়ে, কিন্তু আউট অফ লিস্ট না। The court has taken up the let the matter be released from the list. হাতে নিয়ে নিয়েছো কেন মামলাটা? লিখে নিন এখানটা একটা অর্ডার। Since the writ petition was released from the list by a coordinate bench, it would be fit and proper in the circumstances that appropriate assignment and be it requires appropriate assignment. Accordingly, records be sent to the Honorable Chief Justice for necessary directions.
Maybe kept in the record, Roshi.
আরে নোটিশ দিলে কি করে হবে? অ্যাসাইন করতে হবে তো, নাহলে যে কোনো রিলিজ করলে নিয়ে নেবো নাকি আমি? আউট অফ লিস্ট করলে
Maybe kept in the record.
ঠিক আছে, সার্ভার কপিস করে দিন। হ্যাঁ, এটা ঠিক করে অর্ডারটা করে দেবেন তো। এই যা লিস্ট ভরিয়ে দিয়েছে আজে বাজে মনে। তাতি দাও, তাতি দাও।
I appearing for the state respondent lordship. No. This is matter regarding the dispute between petitioner and bank over the issue of non-payment of loan amount, your lordship. Bank issued demand notice and proceeded to sell the charged property, but in the meantime, the civil court stayed the order, your lordship. Stayed the demand notice, lordship.
Dispute between petitioner and
So why they have come to High Court? Interim order directing the police authority to protect the life and property of the petitioner. You are for the state? Records reflect that petitioner approached the police authorities pursuant to directions passed in title suit number 110/2024. However, the police authority is refused to act on the representation of the petitioner, and as such, the writ petition has been preferred. The state has submitted a report to the officer in charge of Usti police station, which reflects that there was a dispute between the petitioner and the respondent number 7 over the issue of payment of loan, and the respondent number 7 proceeded to sell property under section 13 of the Surface Act. A title suit was preferred at the behest of the petitioner. Be that as it may, since the civil court and since either the civil court or the tribunal under the Surface Act will have jurisdiction to adjudicate the issues, the core issues. Police authority would act only on direction of the civil court or the tribunal. No interference is called for or by the court in respect of the prayer so advanced in the writ petition. Accordingly, WPA number 11874 of 2024 is dismissed. Report submitted by the state be kept with the record server copies. Cholo, next.
Agent 32 minute, can you not today, my lord?
Yeah, not today হবে না, অনেক হয়ে গেছে, অনেক দিন ধরে আছে। Yes, what is your prayer? There's a criminal case, I believe. What are you wanting? I sure it on 21. মামলা করে সব Who are you, accused or complainant?
I am for the petitioner. I have non brief.
Huh?
Not have a brief, my lord.
Yesterday you did not participate. Huh? You got whole of the day. Matter pending since 2024. Huh. No interest on pendency of matters. क्या আছে? Hey, Mr. Sengupta, read this before rising. I will take up the matter. কি আছে মামলা? Whether the petition, what is the role of the locus of the petitioner? একটু পাসওয়ার্ড রাখুন তো, মামলা করে আর হবে না। এই বল বল।
I beg to appear on behalf of the state.
Yes. ল্যান্ডে ঝামেলা তো। What are you wanting? You have land, you have pond, respondent will be disturbing, that is normal.
May I cut short the matter? Petitioner has 1.5 acres of land. He has inherited from his father. The land includes big size of pond.
Whatever, yeah.
My lord, he agreed to respondent. He made an agreement with respondent number 6 for doing pisciculture in the pond for my lord for a certain period, my lord, 2018 to 2000 something.
Agreement expired.
Thereafter expired, and thereafter he is doing the pisciculture.
The respondent.
Money. Yes, this is the thing. Police has, my lord, started 107. Earlier he
to file a fresh representation.
Earlier he has moved one.
File a fresh representation. This was filed when? আরে ওই তো কি হলো? Page
25.
7/3/2024. 1.5 বছর হতে চললো। Learned advocate appearing aiming for the petitioner is aggrieved by the inaction of the police authorities as in spite of informing the officer in charge build the police station in respect of unauthorized and forceful trespass at the behest of the private aid respondents. The private respondents had been adamant in carrying out the PC culture in the water body which belongs to the act of the petitioner. State has submitted a report. Report reflects that earlier for a fixed period of time there was an agreement between the petitioner and the private respondents which has expired. However, the private respondents till date by depriving the present petitioner are continuing their
it is the allegation of the petitioner
are continuing their illegal activity is full stop. Having regard to the nature of the dispute complained of, so far as the right title interest of a property is concerned, it would be the civil court which would decide the issue. Police authority would only ensure that there is no breach of the peace and tranquility.
Police has been keeping
Full stop. At the relevant end point of time, police authorities have drawn up did draw up proceedings under
this
section.
has been done earlier in the year 2023,
under the relevant end provisions of law. Full stop. If fresh inconvenience are faced by the petitioner will again file a fresh representation with the police authorities. Police authorities are directed to act in accordance with law and oversee that no untoward incident results because of the strained relationship. With the aforesaid observations, WPA 11949 of 2024 is disposed of. Report submitted. Be kept with the records. Several copies. Chalo. Next. 34, who is appearing? কি আছে কোন ম্যাটার আমার কাছে দিয়ে দিয়েছে এই সেকেন্ডারি এডুকেশন গুলো আমার এখানে করে দিয়েছে কেন $18 অ্যানাম এগুলো আমি আচ্ছা না রেকর্ডস অফ দ্য দ্যাট দ্য এটা গ্রুপ 2 লেখাই আছে তো দ্য দ্য record reflect that the writ petition should appear under a different classification and has been inadvertently listed before this court. Accordingly, let the writ petition go out of list. Let the same be listed before the court having determination. Next. গ্র্যাচুইটি মামলা দিচ্ছ কেন আমাকে ক্লিয়ারেন্স ওই জন্য করে দিচ্ছি তো চলো কি আছে এটা পুলিশিং অ্যাকশন তো একটা লাইন তো অন্তত পুলিশের কোনো রোল থাকবে না হলে আমি করবো কি করে রেসপন্ডেন্ট পুলিশ অফিসারও আছে একটা কি আছে এলআর প্লট আর এস প্লট পারফর্ম দ্য ডিউটিস 19 জানুয়ারি 2024 কাকে দিচ্ছিল মিস বোস ওয়াজ দেয়ার নো আচ্ছা petitioner is aggrieved by the inaction of the police authority is as in spite of informing the officer in charge of Jamalpur police station. No steps have been taken. Records reflect that last of the representation was sent to the police authorities on or about 19th of January 2024. Prima facie, as none appears on behalf of the state. Ms. Bose, you come. As none appears on behalf of the state. ওর নামটা নিয়ে আমি কি বোস Learned advocate 8 appears on behalf of the state is directed to appear on behalf of the state. Her appearance may be irregularized by the concerned authorities. I have considered the nature of the accusation made in the information which was sent to the officer in charge Jamalpur police station. Having considered that substantial time has passed in the meantime, I direct that if fresh inconveniences are faced by the petitioner, he would inform the concerned police station. Police authorities would oversee that no untoward incident results because of the strained relationship existing between the petitioner and the private respondent number 4. Chalo. With the aforesaid observations, WPA 12251 of 2024 is disposed of.
146. I appear for the respondent number 6.
My lord, I am for respondent number 8, my lord.
8, who is appearing?
There is already a stay granted by
the
competent coordinate.
There is no order over here. Stay over what?
Stay of the FIR. The FIR, they are saying police inaction.
So this is in revision.
Yes. Revision.
You are an accused.
I am an accused. My lord, he is my watchman.
My
lord, I am a publishing company. I supply books.
Conflicting interest. Learned advocate. Your praise for quashing.
Yes, ma'am. Yeah, I have prayed for quashing. It is under a stay. Of the FIR is under stay.
You are an accused.
Yes, I am an accused.
So this person is who? Petitioner over here is the de facto.
Yes, petitioner is a de facto.
Acha. This is arising out of the same case.
Same.
As what is the FIR number, sir?
The FIR number, my lord, is 11
of 24.
Subsequently renumbered as 41 of Barrackpur.
Page number. Page number.
Page 28.
Page 28.
Page 28 is the FIR.
Acha. Learned advocate 8 appearing.
My lord, what happened in this?
No happening, sir. Case is same, it will go to the revisional court. Learned advocate appearing for the petitioner has handed over the order dated 27/8/2024, passed in CRR number 3480 of 2024. It reflects that the subject matter of the C8 is related to GR case number 3848 of 2024, which was renumbered as GR case number 506 of 2024. The present writ petition also involves the same GR case. Consequently, let the writ petition go out or let the writ petition be released from the list as the revisional application and the writ petition is required to be heard by one and the same bench. The records we play is before the Honorable Chief Justice for appropriate assignment. Chalo. Same GR case though. Same GR case. একটু থাকে এখন না
47. To appear for the petitioner.
837 হ্যাঁ কত দিলে
My lord, we attempted to serve the learned government leader's office and notify them.
wait who is appearing
My lord, state
which is your item 837
347, my lord.
what is going on the board why are you seeking special attention madam 837 কেউ appear করছে না কালকে দেবে ছেড়ে দাও appear করছে yes Mr. Sengupta have you gone through that what is there
I need to understand why this Register General has been made as a party. If your lordship kindly take travel to see the order subsequently passed by Justice Sengupta, it reflects there are conflict between the petitioners and their advocates. Now, this gentleman was initially appointed as an advocate. Now, he has been removed. Now, he has come up with a frivolous prayer by making the Register General as a party by saying we are seeking for investigation. Possibly the locus which is he's coming over here is questionable.
Yeah,
kindly have a look. The three order of Justice Sengupta, one after another.
চালাতুন
Paragraph 8 onwards, this story has been made out.
These petitions are pending.
The Mitu Samanto, I do not find the last order of the Justice Sengupta. But 3 orders I have found. The last order, the last page was absent in this petition. The Mitu Samanto's matter.
Last page, this order. What is the prayer which has been on failure to assign? Chibaji Joto Mamla Kurvi Yoko.
Your Lordship, kindly see the prayer millard in that event.
I've considered the records of the case reflect that initially a writ petition was preferred being WPA 17269 of 2023, which was related to
Shiti Police Station, case number 36 of 2023. Subsequently, records also reflect that there were certain issues relating to learned advocates representing the parties. However, one of the orders of the coordinate bench reflect that after the writ petition was taken up and the CCTV footage was also taken on record, and a fresh set of lawyers were engaged, the petitioner took a different stand, particularly with regard to statement, particularly no, the different stand. Acha. Be that as it may, presently the writ petition has been filed with prayers where is respondent number 21? This up to 15 it is over here.
I'm sorry, Millet.
Up to 15 is the respondent.
Yes, thereafter I could not.
Prayer is of respond up to respondent number 21. কি বললাম?
Presently, the petition has been filed with players.
2, 3, 4, and 6K. কি করছে বলো তো আনন্দি? With prayers against the police authorities, particularly with regard to some issues relating to recovery of weapon, search and seizure, and a case is already pending before the jurisdictional court. It would be in the interest of justice that the petitioner takes out an appropriate application before the court, which is already in CC of CTPS case number 36 of 2023. Full stop. As none appears on behalf of the estate, Mr. Sengupta will appear with you.
Put Miss Das.
Mr. Sengupta, along with learned advocate, along with a junior, namely Eta Diyedeve, is directed to represent the state. Their appearance will be regularized by the concerned authorities. Having considered the nature of the prayers so advanced and the directions passed, I am of the view that the interference of the court is uncalled for. At the related stage, petitioner would act in terms of the directions passed above. With the aforesaid observations, WPA 11888 of 2024 is disposed of. না নিউ মোশন আছে তো দুটো থেকে একটা মনে কি আছে তাই না
Yesterday I did that my prayer that your lordship intervention warrant has been executed over the accused person complaint.
1 minute. Just 1 minute. Who is appearing for the state? এই রেকর্ডটা দেখি Mr. Sen has come to court.
Mr. Sen?
Huh?
Yes, he is a regular.
No, has he come?
Just informing. He's on the.
Alright.
আসেনি?
আমার কোনো প্রেয়ার নেই স্টেটে।
Has he come to court today? But give his name over here. He and Oshima Das give their name. He doesn't want to pursue what's the use of keeping the matter.
No, that's all
He's
right.
for-
Of course.
Learned advocate appearing in for the petitioner submits that the purpose for which the writ petition was preferred has been subserved, and as such, further pendency of the writ petition is unwarranted. Mr. Sen, learned additional government leader, appears on behalf of the state in view of the aforesaid WPA 7036 of 2025 is disposed of. The copies just give it.
Giving নামটা দিয়ে দাও
চলো হয়ে গেছে আজকে নিউ মোশন করবো কিন্তু হ্যাঁ উঠে এসে তুমি টেনশন নেবে না নিউ মোশন টেনশন নেবে না কে নাও কিন্তু একটা 28 বাজে হ্যাঁ ও আছে তো হ্যাঁ বারুইপুরের লোক হ্যাঁ তুমি কালকে নতুন গান আপলোড করোনি কালকে ছুটি পেয়ে গেলে হ্যাঁ 4 থেকে
My lord, my lord, in item number 4, my lord, I was only praying, my lord, may takes this matter after a week, my lord. My lord, actually, my lord, what
You
has
go
happened
to
is,
up
my lord,
in the monthly of September,
my
Mr.
lord, what has
Tiwari.
happened is, my lord, due to
Second time it is being called.
no, it's my mistake, my lord, I couldn't serve upon the GP, my lord, and as it is running in the list, my lord, they are not accepting it. So, my lord, I was only praying, my lord, may takes this matter and with a
September,
liberty, my
September.
lord.
Do it in the month of September, it will come up. Chalo, Ashwin. Learning advocate appearing for the petitioner submits that service has not yet been completed. List the read petition in the monthlies of September 2025 under the same heading.
May I only pray, my lord. Can it be, my lord, in August, my lord, monthly list of
September. September. Not question. Yes.
Private respondent.
Show appearing for petitioner, my lord.
But charge sheet has been submitted in this case, my lord.
And my lord, these are matters being second time called. How many times I will call these matters? Not, I'm not counting yesterday. Yesterday I have called the matters, but prior to this also these matters were called. Regularly, if this being done, I can't do anything. Same prayer, September code in same order. Learned advocate need learned advocate appearing for the petitioner. Praise for an accommodation.
Charge sheet has been submitted.
My lord, judge trial is also
What I've come to
concluded.
learn from the private respondent, my lord, that judgment has been passed and
concluded, my lord.
What to do? Somebody is praying on personal grounds. Learned advocate for the petitioner prays for an accommodation on personal grounds. Ms. Ahmed, learned advocate appearing for the state submits the report.
तुमको नहीं मिला तुमको accused हो.
Let the same be kept with the record. Learned advocate for the respondent number.
Private respondents.
Private respondent is present. In view of the accommodation sought for, list the reparation monthly list of September 2025 under the same heading. Same heading দিয়ে না motion 2 করে দিন under the heading motion 2 যারা যারা টাইম নিচ্ছে সব motion 2 আগেরটাও motion 2.
May I have a copy of the report, my lord?
No. Next. Yes.
Petition is the better lordship. The petitioners have been ousted from the role property lordship without any judicial order lordship by the police authorities. Despite being lordship, surface application pending and lordship section 138 case pending, where I've been lordship, petitioner have been arraigned as an accused lordship is in.
Who is the finance company?
I appear for the finance company, Millard. Was it taken, Millard, pursuant to an order of Millard by the learned executive magistrate, and thereafter possession has been taken. And there is not me any order, lordship. Right now, executive magistrate, surface application is pending, lordship.
The petitioner the petitioner to Gallo.
On the second page of the report, my lord.
The concern and to physical business. Pursuant to DM has passed an order, sir.
So I don't have any instruction as much instruction as the service application is pending, lordship.
No, application you may have taken. There was no interim order to produce before the petitioner has approached the court, alleging that he has been thrown out from his residence by the police authorities. State has submitted a report. Report reflects that there was a direction received from the district magistrate Barasat for providing necessary police assistance for allowing the private respondent number. Company is what respondent? Private respondent number 2A. 2A লিখেছে তো 2A. 2 is branch manager. 2A is Bajaj Finance. Private respondent number 2 capital A to take possession of the property.
Subdivisional officer.
That's not the DM's order is sufficient. Sir. The contention of the petitioner is that applications are pending before the debt recovery tribunal.
Yes, DRT3.
DRT3. Be that as it may, since the police authority is have exercised the powers under direction of the district magistrate, they cannot be held at fault. Full stop. Consequently, petitioner would Since the petitioner has applied before the debt recovery tribunal, this court is devoid of passing in any directions. Accordingly, EWPA number 11122 of 2025 is disposed of. Sir,
Given an opportunity of hearing lordship before the executive magistrate. First time lordship.
no, DM, no opportunity is required.
Can't be. Lordship, may I get
Report submitted be kept with the record server copies.
a- may I get a copy of the
Copy of the report be handed over to both the parties. Huh?
I'm for the response number 1 to 5. This is the third time, Lord, your lordship is appearing.
Evidence service file be kept with the record.
Lord, I'll just submit my.
Just 1 minute. Who is for the petitioner?
6, item 6.
It is 7. This is my irritation also.
Lord, this is the third time. You know, you actually just browse over the lines of your lordship's order at page 5. Just, Lord, this is the dispute between the brother and sister. Your lordship, your page 5 is your lordship's order, not your lordship. Kindly see. Page 5 it starts and 6 your lordship kindly. It has already been adjudicated. Nothing remains. Absolutely a civil dispute in nature, my lord.
Earlier observed. Earlier.
কি বলি বলো তো একই মামলা একেও সার্ভ করছে তো ভুলভাল মামলাগুলো nobody is doing repeatedly I am calling this man this is
Last time, 2 times, my lord, they have taken adjournment.
so that is earlier yesterday I have called whole of the list and yesterday I am the last person to disbelieve the lawyers were not in a position to come to court.
That I do not know, my lord. I have seen in my own eyes. I have seen from Lord 8:30 to 11 o'clock. Road was clear. I have seen in my own eyes because I had been there. Not I have seen. This is my personal knowledge, my lord. I have seen.
Whoever appeared they have
But
done
I'm
their
sorry to say, my lord, because since your lordship already passed a matter in this regarding this yesterday's matter, but I have seen the road was clean. There was no traffic. Absolutely, there was no from. I have come from city to Central Avenue.
I know
there
that,
was no traffic congestion, my lord.
this attitude must change sir, of
But
the
that
bar.
I can say, but
I
will
today
say
have
that there was no
today I have
traffic
told
disturb-
that you should have
traffic disruption.
recalled the resolution. Could have instead of 10:30 from 11 the court will sit something like that. Every day court will not work that is not possible. চলে ডিসপোজ অফ করে দিই আর আমি ঠিক আছে চলে আসুন
Nothing remains in this, not the dispute between the brother and sister.
আচ্ছা petitioner has
There was a rule
approached
that
the
has been
case
cancelled.
court praying that the police authorities that he has pointed out that is enclosed along with the report.
Yes, I have already the report. I have already.
কি বললাম where the police authorities did not কি বললাম petitioners approached this court as the police authorities did not respond to the representation which was furnished. Learned advocate A8 for the private respondent and number your respondent number
No, 8 to 10.
respondent number 8 to 10 is present you she's appearing with you.
No, she's appearing with me. But
You're not a private respondent.
no.
Achha.
Samani to me,
State 8
this is a
submit
party
8
involved.
report. The report reflects that earlier directions were passed in WPA 22472 of 2024. Having considered that the nature of the dispute complaint of is absolutely a private dispute, the police authority is have correctly have properly not interfered in the dispute. Full stop. Petitioner has there were earlier necessary directions having been in past. Further prayers which have been advanced and are for the purposes of circumventing the processes of law cannot be entertained in the present application under Article 226 of the Constitution of India. Consequently, WPA number 11132 of 2025 is dismissed. Report submitted by the state be kept with the record server copies. নাম দিয়েছে দিয়ে দিন আর কি করা যাবে চলো নেক্সট মামলাটা দাও
Number 8.
Relation. Is any junior member is there? If
Mr. Bellal Sheikh.
Bilal, yeah. The read petitioner has been in preferred as the petitioner felt insecure or odd in respect of protection of his life and property. Petitioner has earlier approached this court by way of WPA number 28460 of 2022. As none appears on behalf of the state, Mr. Bilal Sheikh, learned aid advocate, is directed to represent the state. His appearance may be regularized by the concerned authorities. Having regard to the core subject issue in the read petition, primarily I find that the dispute is relating to demarcation of property. Full stop. The nature of the dispute do not call for or interference of the court, as the same is a private dispute. Full stop. However, the police authorities would oversee that no untoward incident results because of the strained relationship existing between the petitioner and the private respondents. So, with the aforesaid observations, WPA 11137 of 2025 is disposed of. No.
I appear for the petitioner.
Yes.
The private obtained the decree from the civil court against the private respondent so far as his ingress and egress to his plot of land through a passage. That decree, my lord, nobody has challenged. And finally, then my lord, what the respondent did, my lord, they have my lord, dug up the passage, made it unusable so that I cannot approach my land, also in spite of the decree. I approached the executing court because I have to get it executed. Executing court has not passed an order saying that the decree doesn't say that you can restore and repair the passage, so I cannot pass any order. The executing court will not interfere because it cannot go beyond the decree. The position is, today my right over the passage is declared. My right has crystallized as per the Supreme Court judgment, but I cannot use it because of the digging up and obstacle created by the private respondent. I only seek, if your lordship thinks kindly appoint a special officer, I will just restore it, Lord. I will not change nature and
kindly turns to page 13 once, they seek adequate protection to the petitioner. This is a prayer B and his family members so that they can peacefully use the stretch of road measuring about 8 feet wide. That is the only path of ingress and egress used by the petitioner and his family to access the subject premises. This TS number 131, I find, my lord, from their own application is there at page page 76. They have also filed another petition before the executing court, my lord, to carry out. Perhaps, my lord, if there is a new cause of action that has arisen, that also pertains to the civil jurisdiction.
No, it cannot. But the executing court rejected saying that I cannot go beyond the decree. This is the order.
So, my lord, perhaps
if the private respondent, their prayer is for ingress and egress through plot number 426, 26 their prayer, prayer C, issued in the nature of mandamus commending the respondent to provide adequate police protection to the petitioner to cause repair work to the stretch of road measuring over 8 foot wide, 20 foot long under plot number 626. That is the only path of ingress and egress used by the petitioner and his family. But our case is there, they are using the land, not plot number 626. That is plot number 631. That is, I am the owner of that plot. My lord, kindly direct the district magistrate or kindly add the bureau, my lord.
No. File affidavit, কিছু করার নেই। পরে judge করবে, আমি আর করব না। Since the petitioner has prayed for egress and egress to his property through plot number 626 as referred to in the as of the writ petition, learned advocate appearing for the private respondents disputes that plot number 626.
They are the owner of the plot number 631 and they are wanted to use that plot as a
Plot number কি বললাম learned advocate for the private respondent and submits that although the prayers have been in advance in respect of plot number 626, but the petitioner intends to use plot number 631 which belongs to the private respondent and full stop. Your report.
I don't have the report now.
ঠিক আছে. Having considered the nature of the dispute which relates to title of the property, the police authorities have hardly any role to play. However, since the respondent has taken up an issue relating to the plot in question, through which the petitioner claims to have egress and ingress, let affidavit in opposition be filed by the respondent number.
private respondent.
You are the only private respondent.
529.
Is private respondent numbers 529 by ওই এক মাস সময় দিন আজ কত তারিখ 22 তারিখ by 22nd of August 2025 affidavit in reply if any be filed by ওই ইয়ে করে দিন 12th of September 2025 list the writ petition in the month of November 2020. Under the heading here.
Question of maintainability of the writ petition may be kept.
Learned advocate, you want to file affidavit? File করো সময় দিচ্ছি.
But let the police not help us so that
the state intends to use an affidavit in opposition questioning the maintainability of the writ petition. Accordingly, the state would also be at liberty to use affidavit in opposition within the time frame as within the time frame as directed above.
Grateful.
কিছু এফিডেভিট দিয়ে বেরিয়ে যায় বুঝতে পারলেন তো হ্যাঁ প্রপার ডিসপোজ করে লাভ নেই এফিডেভিট সার্ভিস ফাইল বি কেপ্ট দ্য নেক্সট
For the respondent 1 to 5.
I'm the respondent number 6, 8 and 9.
Not your lordship, I see page 63, your lordship.
63 কি করেছে
Direct me to make a press representation. Police authority. Police authority will act in accordance. Not
No cognizable offense has been disclosed, my lord. Your lordship, however, police has taken action under section 126 of the BNSS. Your lordship, kindly see.
ভালো কথা
And in terms of your lordship, further the complaint.
Petitioner is agreed by petitioner is agreed in petitioner is petitioner is agreed by the fact in spite of the representation dated 27/3/2025 addressed to the inspector in charge Noida police station. No steps have been taken in spite of there being violations as violations being reported to the police authorities. Full stop. Learned advocate for the state has submitted a report. The report reflects that since no cognizable offense surfaced out, police authority is restricted themselves by drawing up proceedings under section 126 of the BNSS. Full stop. Learned advocate for the private respondent numbers
6, 8 and 9.
6, 8 and 9 submits that 2 civil suits being TS 102 of 2022 and another
126 of 24 block.
And another TS.
No,
what?
sorry, title shoot number 10222.
Only one civil.
No,
They did not get any injunction.
এটা পুলিশ ভুল লিখেছে ওটা একটাই সিভিল কেস লিখুন 102 of 2022
একটাই 102
is pending. Having considered that the police authorities have taken steps but could not on inquiry could not unearth as to whether any cognizable offense has been made out. I grant liberty to the petitioner to approach the jurisdictional magistrate under the relevant provisions of law. Learned magistrate would assess regarding the veracity of the information unfurnished and as to whether any cognizable offense is made out and thereafter pass necessary directions under the relevant provisions of law. With the aforesaid observations, WPA number 11-214 of 2025 is disposed of. Reports are submitted. Be kept in the record. A copy of the report be handed over to the learned advocate appearing for the parties.
May please, Your Lordship, my
Yes.
I am here on behalf of the fourth to
my lord, kindly come to page, my lord,
Happy reporting
28, my lord, 28,
thorough
clear
investigation.
everything, my lord.
Yes, yes.
My lord, initially I have lodged an
2022 मामला तो
July 2022.
The first one ended in FRFM.
Yes.
The second one, reinvestigation has been directed. The petitioner, not the wife of the petitioner, he was supposed to provide the medical documents. In spite of several requests, he did not turn. She did not turn up.
Where are your medical documents?
No, this is my lord. This is against my lord. The wife is the accused. My lord, kindly come to page 28. My lord, everything will be clear, my lord.
Page 30 is what?
My lord, 30 is the representation. 28 is a magistrate order, my lord. Why he has passed, my lord, the order of further investigation. My lord, paragraph 4, my lord. In 2022, my lord, I have lost the complaint. It has culminated into FRT. Then, my lord, I filed Naraji. Then, my lord says, admitted position in the incident case, paragraph 4. That the assault, such and such. Neither has been examined, nothing has been done, my lord. Order was passed 1 year back.
Yes, সেই জন্য জিজ্ঞেস করছিল জয়ন্ত have you examined the doctors?
We have examined the doctors, but the medical documents is lying with the wife. She has not supplied to us even.
Wife is the accused.
It are older documents. The hospital do not possess these, my lord.
Which year incident?
2022.
2022 documents are not available. First time you did not collect.
No. And the second time when we went there, those are not lying with the hospital.
The incident was made in the year 2016. But what has happened, my lord, due to torture, my lord, he was aborted. Thereafter, my lord, I lodged a complaint before the police authority, and FIR was lodged at the same time. My lord, your lordship, can you say that he admitted in the hospital? Your lordship, can you see the complaint?
I am not doing the trial that I will see.
As I filed,
No, I stand corrected, my lord, in 16. Incident of 16. Complaining about incident of 16.
Where are the who are you de facto?
My lord, I am the husband de facto. Accused number 4 is the wife. My lord.
Against the wife regarding abortion.
So matrimonial dispute is there.
Yes. Complaint against the wife regarding abortion.
But my lord, in spite of the order passed by the London magistrate for further investigation, my lord, 1 year, nothing has been done. Last July, my lord, order was passed. But they could file the closure and others, my lord. Initially, they have filed, my lord. We have proposed. Court was satisfied, directed further investigation.
Within 3 months, you submit whatever you have. Petitioner. Within 3 months, they will file whatever. Acha, records reflect that pursuant to the order dated 4/7/2024, police authority had undertaken for further investigation of the case. Full stop. Consequently, Jagacha PS case number 248 of 2022. Was reopened and the investigation resumed. However, today a report has been submitted on behalf of the state which reflects that as a counterblast to the case being Domjul PS case number 1089 of the 2017. The present case was instituted at Jagacha police station. Police authorities on different dates issued notice to the injured victim, namely Shatabdi Chakraborty, for our supply of the reports
My lord,
and medical
I made
documents.
just correction, my lord. This is not a victim, my lord. He is accused in this case.
Okay, victim injured করে দিন victim take injured আচ্ছা
She may be injured in his
full
case.
stop.
Her case.
However the documents relating to Habra State General Hospital, in spite of efforts, could not be collected till the aid by the investigating officer. The incident complaint is of the year 2016. As such, the investigating officer is finding it difficult to retrieve the medical documents. Having considered that efforts are being taken by the investigating officer, I am of the opinion that since the incidents complained are of 2016, the FIR was of the year 2022. The initial report in final form was submitted in the year 2023.
No, no, 23, my lord.
23.
23.
And the further investigation is being carried out pursuant to the direction dated 4/7/2024. Police authorities will exhaust their efforts and try to submit their report under section 173 CRPC, preferably within a period of 3 months from the date of communication of this.
May I get a copy of the report, my
With the aforesaid, with the aforesaid observation, WPA 11242 of 2025 is disposed of. Reports are submitted. It be handed over to the petition.
The affidavit is submitted.
Abra, HABRA. সার্ভিস বললো কোথায় ওদের সাবমিশনে লিখেছি তো হ্যাঁ এভিডেন্স সার্ভিস ফাইল উইথ কেপি দ্য রেকর্ড নেক্সট তাতে
Grateful, man.
My lord, it's my property, my lord. After getting the order from the civil court, my lord, I started the construction, my lord.
After to him, lordship, to treat the complaint as an FIR, lordship, and
FIR registered.
They have broken the boundary wall, stolen the property.
Yeah, that is also registered. Your case is already registered.
Give the report. Petitioner has approached his court as, in spite of information furnished with the officer in charge Raja Bagan police station, no steps were taken. Acha. The state has submitted a report which reflects that pursuant to the complaint received, Rajavan PS case number 96 dated 17/6/2025 has been registered for investigation.
And investigation is in progress, lordship.
The investigation of the case is in progress, and both the parties have also been directed to maintain peace and tranquility. Having regard to the steps taken by the police authorities and a case being registered, I direct the petitioner to ventilate his further grievances before the appropriate court of law. Learned advocate for the private respondent number 4 is present. However, since further issues are not being dealt with by the court, the denial of the private respondent in respect of the incidents which have been in complaint of at this stage, I'm of the opinion cannot be taken into consideration. However, the respondent would be at liberty to canvass such issues before the jurisdictional court, which is in CCN of the criminal case. With the aforesaid observations, WPA 11283 of 2025 is disposed of. Report submitted. Be kept with the records.
Lord, I'm appearing for the petitioner. Lord, number 13. Lord, in this case, Lord,
we handed over to the learner appearing for the petitioner. Yes.
My lord, in this case, my lord, on the last occasion, the state, my lord, had said that I had not complied with the 91 CRPC notice. Lordship, may kindly takes up, my lord, page number 36 of my application, thereafter that page number 37.
No,
Lord, this is with regard to an existing racket which is going on, my lord, where certain persons in the name of film production say certain, my lord, famous actresses would be participating, takes money as an investment, my lord, and thereafter that, my lord, all this money is being used, my lord, in various other places. But similarly, this person has fallen into this trap. Now, two things were required by the investigating agency at page number 36 in 91 notice. Our response is at page number 37, my lord, where we have given the bank account transactions. It is all in white, and my lord, as well as the so-called purported, my lord, film making agreement, my lord, which is there. My lord, we have explained completely with regard to the entire backdrop of the case. My lord, still then, the state says that I have not complied with 91. And also says that the accused has been given 41 a notice. My lord, this was what was submitted on the last occasion.
Now, my lord, this is a case, my lord, where, my lord, this is an existing racket, my lord, which is going on. My lord, till date, my lord, I don't know whether my 164 has been taken or not, whether these, my lord, documents have been, my lord, carried further or not, whether the bank accounts of the accused persons have been checked or not, my lord, nothing has been done, my lord, because this is how the money is rolling, my lord, from various other persons also. My lord, because, my lord, there are two persons involved. One is so-called director, another one is the so-called producer.
This can one is who filed this?
My lord, I have taken out an intervention application, my lord.
My lord, accused intervening in my petition, my lord, praying for, my lord, superior investigation.
My lord, I am for Procedural, my lord. Two
He's an
notices
accused.
by the police station concerned in connection with this particular case, my lord.
Two cases?
Two notices have been served to me, my lord. I have annexed it as A1 and A2, my lord. Through this intervention application, my lord, my only contention is, my lord, multiple number of times this police station has called me, has asked me to appear before them. I have been to the police station on several occasions, my lord. Even on the last day, I have mentioned in the application, my lord, copies are being given to. I am serving copies to the petitioner and the state.
Mr. Vitro, under the new BNSS, under 193, you are supposed to inform after 90 days regarding the progress of the investigation. I am directing you for compliance of the same regarding what have you done to be informed to the petitioner. I am disposing of the writ petition.
We have already filed charge sheet.
But this is an absurd stand, my lord. Charge sheet has been filed, whether the bank accounts have been traced, but these are the cases in which they are trying to shut it down. Because this now, my lord, because, my lord, what happens, my lord, these are these rackets, my lord, which are going on.
হাত থেকে বেরিয়ে গেছে কি হবে?
But over here, my lord, two persons, my lord, are very powerful, my lord. Both the film producer and the film director.
তুই ঠিক আছে হবে তো কেসে আবার লাইভ করতে হবে
But it just indicates that no bank accounts have been seized of the accused person to show this
I
transaction.
have not seen the case diary. Learned advocate.
Let them, my lord, then call for the case diary once, my lord.
No, you go on 193.9. I'm
Yes.
granting.
After, my lord, giving us a progress report, my lord, with regard to what they have done, my lord. That would be helpful for us.
Progress report. You file under 230, you are entitled to documents.
Very well. Lordship answers that liberty.
Learned advocate appearing for the petitioner is agreed by the fact that in spite of complaining, in spite of Govinda Sharma PS case number 34 dated 8/13/2025 having been registered for investigation under the relevant provisions of law. Oh, it add করে দিয়ে আগে. Let his addition of party be allowed.
Averments made by him is disputed by me, my lord. Your lordship.
একটু আগে এটা করে দেব হ্যাঁ CN 1 of 2025 the applicant has prayed for addition of party. What have you made?
My lord,
intervening probably.
As a necessary party.
আচ্ছা কি বললাম? Prayed for intervening in the present with petition for being added as a necessary party. Having regard to the locus of the applicant, the same is allowed in spite of the objection raised by the learned advocate appearing for the writ petitioner. Full stop. Accordingly, CN 1 of 2025 is allowed.
Averments made therein are disputed, my lord, by me, not to be treated as
kind of objection. I have said that. Next. That is by the 34 dated 8/13/2025 having been registered for investigation. Another provision. However, no effective steps have been taken by the investigating agency for unearthing the truth, and the petitioner has suffered irreparable loss and injury for the act and action of the investigating authorities. Full stop. Learned advocate for the state has submitted a report. Report reflects that the investigating agency, after conducting investigation, has submitted a charge sheet, being Govinda Sharma PS charge sheet number 40, dated 9/7/2025, before the learned CJM Alipur. Having regard to the fact that charge sheet has been submitted before the jurisdictional court, I am of the opinion that if the petitioner is aggrieved by the investigation, petitioner will approach the jurisdictional magistrate for necessary reliefs in respect of the issues relating to effective investigation. Full stop. To that effect, a petitioner would be at liberty to take out an application under section 230 of the BNSS, supplier of copies, and thereafter thereafter advance necessary prayers under section 193(9) of the BNSS. Then a magistrate would, if such an application is filed, dispose of the same within a period of 60 days from date of filing of such
Deeply
application.
grateful, much grateful. Deeply grateful.
With the aforesaid observations, WPA 11295 of 2025 is disposed of. Report submitted be kept with the record server official.
Copy of the report may be handed over to us.
Be handed over to learned advocate appearing for the petitioner. Chalo, jo.
Deeply grateful.
I am for the petition, Lordship. Lordship,
Yeah.
petitioner purchased the land Lordship from the husband of the private respondent Lordship, and sale deed was executed Lordship. In the sale deed, it was declared that the total measurement of the land was 1 kata and 12 chotas, but it was fraudulently declared Lordship the measurement of the total land is 1 kata and 3 chotas Lordship. And now, after knowing that petitioner, whenever he is trying to approach the private place, as the petitioner
Approach for what? Return of the money. What are you wanting?
Lordship, approaching for Lordship return of the money and also to discuss about the matter Lordship, but he is not the custodian of the said premises Lordship, and the private respondents are the permanent residents.
Go before the jurisdictional court, sir. Police has got nothing to do. Absolutely a private dispute.
Lordship, but she is threatening.
The threatening will be there, sir. Petitioner is agreed by the fact that a property was purchased where representation was made by the private respondent. Have you made them respondent or no?
Yes, yes.
Private respondent number 4. Actually, a property was by the 4 in respect of the description and area of the property, which on subsequent measurement the petitioner found to be not matching. To that effect, petitioner intended to discuss the issues with the respondent number 4, but the respondent number 4 along with her associates had been threatening the petitioner with the aid of local miscreants. Full stop. Learned advocate for the state has submitted a report reflects that police authority is on receipt of information has drawn up proceedings under section 126 of the BNSS. Having considered that the police authorities are aware regarding the nature of the dispute, I direct that the police authority would oversee that no untoward incident results because of the strained relationship existing between the petitioner and the private respondents. The private respondent number 4, full stop. Gallo, petitioner would be at liberty to ventilate his grievance before the jurisdictional civil and criminal courts. The concerned courts will assess regarding the genuinity of the accusations and pass necessary orders as it deems fit and proper. With the aforesaid observations, WPA number 11300 of 2025 is disposed of. Reports are submitted. We kept with the record. A copy of the report be handed over to learned advocate appearing for the petition. Next. Yes.
Initially, their possession was disturbed and they filed a civil suit.
What are you wanting? Fast.
I am praying for an execution of this as per the deed.
Execution of?
Execution as per the deed.
Yes.
Permanent injunction. Let them give me necessary protection so that I can cultivate my land.
The protection part the police can take care of, but regarding my lord, cultivation of land and peaceful possession, the police authorities, they are not empowered to do unless there is a specific direction by the civil.
Is aggrieved by the inaction of the police authorities, as in spite of representation, no steps were
126, 130.
as no steps were taken.
But I have only one copy of the report. Lordship may kindly excuse me.
Petitioner praise that there is insecurity, particularly with respect of protection of the property, and as Consequently, he is not in a position to cultivate the land. Full stop. Learning advocate aid for the state submit is that already the police authorities have drawn proceedings. Shua Shallar and Gopinath Hallar. Against the respondent numbers 5 and join to আছে নাকি 5, 6 and 7.
5 to 9.
Now they have done a proceedings on the 5,
6 and 7.
Having considered that the police authority are completely aware regarding the dispute and difference between the petitioner and the private respondents, I am of the opinion that police authority would ensure that no untoward incident results because of the strained relationship existing between the petitioner and the private respondents. So far as the other issues are concerned petitioner would be at liberty to agitate the same for redressing his grievance. So far as the other issues are concerned, agitate before the appropriate forum. Full stop. In view of the force aid for the pendency of the repetition is unwarranted. Accordingly, WPA 11302 of 2025 is disposed of report submitted aid with the record server copies. দিন শেষ করে দিই আর অনেক সময় গেছে
The writ petition contains a letter of complaint which is dated 1st of May 2025. This page 41.
Yes.
This does not disclose
সেখানে এসে লক্ষ্য করি আমার ঘরে থাকা লোহার খাট
after this
ও আমার ঘরে তালা মেরে
this is more or less of a civil in nature, but after this the writ petitioner has lodged another complaint on 21/5/2025. We have registered an FIR, recovered certain articles from the possession of the opposite party.
আগের দিনই করা উচিত ছিল মাল সরিয়ে নেবে মানে চুরি করেছে চলে আসবে Learned advocate appearing learned advocate তো নেই records of the writ petition reflects that an information was furnished to inspector in charge Amdanga police station wherein the incident complaint of was related to 1st of May 2025. Full stop. The gist of the allegations were the petitioner's articles were removed from his residence and thereafter a padlock was affixed. Learned advocate 8 appearing for the state has submitted a report reflects that although the said representation of 1st of May 2025 was not acted upon, but subsequently another এটা কাকে ধরে নিয়ে গেছিল হ্যাঁ নাসিরকে ধরে নিয়ে গেছিল
from the shop of Nasir Mondol.
না কাকে ধরে থানায় নিয়ে গেছিল You were inactive on 1st of May. After 21st of May, you became active. যাই হোক নেক্সট কি বলছি হ্যাঁ
complaint
but subsequently another information was furnished by the petitioner on 21/5/2025. এটা কি সন্ধ্যা রবিরা this is all
against respondent number 4,
So this is-
second page, 4th line.
no, it's all right. This is the Shondha Robida. She is the complainant in both the huh?
Second
petitioner to Shondha Robida. Yes. কি বললাম
yes Shondha Robidas.
Consequent to which Amdanga PS case number 492/25 dated 21/5/2025 was registered for investigation and
A Caesar list is at the previous page.
কবেকার 21/4 লিখে দেয় এইসব থানায় এই জন্য ল অ্যান্ড অর্ডার থাকে না বসে আর না Where is the Caesar list?
My Caesar list is 4th page. of the report.
Registering case on 21st of May, saying 21st of April, Caesars was there.
No, my Caesar list first at the top.
21/5 অনেকগুলো জিনিস পেয়েছে তো কেডলি থেকে আরম্ভ করে সব কি বললাম and stolen articles were seized from the shop of one Nasir Mondol. Nasir or Wazir?
Nasir.
Nasir Mondol. Having regard to the fact that the police authorities have already taken steps, the primary grievance of the petitioner is addressed. So far as the issues relating to possession is concerned, petitioner would approach the jurisdictional courts for necessary relief. Chalo. With the aforesaid observations, WPA 11322 of 2025 is disposed of. Report submitted, we kept with the record server copies. So,
Number 17. Better. I'm paying only after all the report.
এখনো সার্ভিস হয়নি কেন মক্কেল আর দিয়ে যায়নি পয়সা নেই সেকেন্ড টাইম আর আসেনি পয়সা দিতে নো পেমেন্ট টিল ডেট Planning advocate appearing aiming for the petitioner pays for an accommodation to await service upon the respondents. Accordingly, list the petition on the of September 2025 under the same heading. Chalo. Same heading na motion 2.
18. No, I am for the petitioner.
Bah. Who is for the state?
I am for the private response 5.
I registered sale of deed, my lord, became the owner of land, my lord, thereafter possession by cultivating the same. The private respondent without any authority of law, my lord, entered the land, my lord, and discarding for possession and assaulted the petitioner, my lord.
Assaulted? Yeah,
Complaint, my lord. Thereafter,
there is a long pending dispute between the petitioners.
156 160
Well, I go.
Landed magistrate, HUD magistrate, my lord.
Yes, what have you done?
There is a long pending dispute between the petitioner and private respondent over the issue of ownership
I
of
have
land matter.
registered
They are the neighbors.
No, not neighbors. I filed the suit. But I got the decree that has been affirmed up to this honorable court. Thereafter, I have taken possession. Manad, I am in possession. Manad, can you see? The police have initiated proceeding, and all those proceedings have been stayed by the learned court below. And can you see, Manad, that my decree?
Civil court. আমি কেন দেখতে যাবো
all the things have been stayed.
Petitioner and the private petitioner and the private petitioner complains that he has purchased a property EE over VEH. There has been in continuous
This is
interval.
the order of the High Court. I got the decree.
At the base of the
And I got permission.
Acha, no more. Acha. It has also been submitted that in spite of informing the police authorities, no steps have been taken. Learned advocate for the private respondent and
all the proceeding has been taken that have been stayed by the learned court below. This is
respondent number 7. Respondent number 7.
Respondent number 5.
Respondent number 5 denies and disputes the accusation.
7 times 1 year back.
Aims the ad. He has court orders in his favor to establish his right. Learned advocate aid for the state submits a report. Report reflects the ad. Initially, a case was registered on the basis of information furnished by respondent number 5, being Damanavara PS case number 43 of the 25. Subsequently, petitioner filed an application under section 163 of the BNSS, having considered that the police authorities are well aware regarding the dispute over the property between the petitioner and the private respondents. Police authority would oversee that no untoward incident results because of the strained relationship existing between the petitioner and the private respondents. So, whereas the other issues are concerned,
The petitioner and the private respondent would settle their dispute would before the appropriate forum. With the aforesaid observations, WPA number 11376 of 2025 is disposed of.
Well, may I have a copy of the report, madam?
Copy of the report be handed over to both the parties. Sure. Evidence service file be kept in the record.
I'm on respondent number side, 7 died.
I'm led by Mr. Jawaharlal Dev, my lord.
Give the name. Give the name.
19.
Chalo, কি আছে? Next.
Lordship, Mr. Torunjyoti Theory will appear in this matter on
Yes.
behalf of the petitioner, but he is in court number 8 for another matter.
You do the matter.
My lord, in item 19, I appear for the state respondent.
Yes. Ready. Ready. You are ready.
Yes, ma'am. I'll let
Lordship,
him.
kindly give a short passover.
No passover, madam. 5 times I have called
My lord,
this
report
matters.
maybe.
What is your problem? Why have you come to court? You've got a copy of the petition. You have to set aside washing. He saw that private respondent sent a comment to his WhatsApp group. শুনলাম পতাকা নাকি তুলে ফেলেছে অজয় পতাকা What is this CFDEL? To produce a case diary, I want to see the case diary. Report submitted by the state learned advocate for the petitioner is present. The report submitted by the state be kept with the record. Learned advocate for the state is directed to produce the case diary of Gopal Nagar PS case number 268 of the A25. Release the repetition under the heading for orders in the monthly list of August 2025. Server copies.
Number 20.
On item number 20, I am appearing on behalf of the station.
Yes, what is your report?
Already charge sheet has been.
Yes.
Thank you.
I behalf appear.
Just 1 minute. Yes, what are you wanting?
My lord, I want, my lord, investigation of my complaint, my lord, which I raised on May 2nd, my lord, by
May
2nd, 2025, my lord. My lord, the complaint is at, my lord, page number 43, my lord. My lord, the case is, my lord, that, my lord, the grievance was against my in-law and my husband, my lord. My lord, the sections that were incorporated, my lord, by the investigating authorities was section 85, 316 subsection 2, 117 subsection 2, 3 subsection 5 of the BNS, 3(5) of the Dowry Prohibition Act, and, my lord, section 6 of Protection of Children from Sexual Offences Act, my lord. Now, my lord, after the registration of FIR, my lord, which is evident from the case record, the police did not take any steps in recovering my Sridhan articles. There was, my lord, huge ornaments were gifted to me during the marriage. Now, my lord, the FIR was registered on February 7, my lord.
The jurisdictional court is in CC. What will 226 court do?
My lord, may I, my lord, say something, my lord? My lord, thereafter, my lord, the seizure that took place, my lord, was after months of registration of this case, my lord. Now, on the date of seizure, my lord, when the IO went to the place of occurrence, my lord, I raised a complaint that, my lord, the IO did not seize my gold ornaments, my lord. To that effect, I raised my representation, that is at page number 39, my lord, 39 onwards, my lord. Thereafter, my lord, no steps have been taken by the investigating authorities, my lord. Then, and my lord, I allege, my lord, biasness.
So each time again today go and file a complaint, an investigation is completed, a court is insisting of the matter. You want to deal with the police authorities parallelly.
No, my
That
lord.
is what you are doing.
My lord, kindly.
You want your recovery or you want on gallery show?
My lord, I want my recovery.
The 226 is for gallery show, I find.
My lord, kindly cease, my lord.
Statutory courts are insisting of the matter. Why are you invoking this? Judicial courts are passing directions.
My lord,
Cognizance has been taken on the offense. You are not going to the court. You are coming to the writ court. Why?
My lord, I shall explain, my lord. Kindly give.
Please, sir.
I'll explain, my lord. I'll explain, my lord, the doubt of the court, my lord. My lord, when we raised our first representation that no, you have registered a complaint, but you have not conducted any seizure. That was in May. My lord, my mail was on May 15th, my lord. Thereafter, when they are in my representation is pending with the authorities, my lord, they file this charge sheet, my lord. Suddenly, without
no, prior to that charge sheet has been submitted in the month of April.
My lord, kindly takes up, my lord.
These on properties has been seized, my lord. Kindly see my report.
This is long. This is usual. They will say main things have not been seized. This is usual. Sir, you say 226 will sit on conviction cases also.
No, my lord.
Why fundamental right goes off if person is convicted?
My lord, my lord.
You are unnecessarily invoking the 226 courts when the statutory courts are insisting. You want to just ignore, get a blanket order from these courts to create a dominance in the criminal courts.
That's not the.
That's obviously because 226 has got nothing to do when a charge sheet has been submitted.
My lord, there is also counter case by the family members against me, my lord.
So there will be, sir.
My lord,
Matrimonial disputes are like that only.
My lord, the investigation was carried out in respect of one FIR. Charge sheet was submitted, another FIR. Nothing has been done, my lord. It is still pending the FIR against me, my lord. That's why, my lord, the writ application was preferred to club these investigations and proceed on the same manner, my lord.
Petitioner is aggrieved regarding the outcome of the investigation arising out of case the Honorable PS case number 150/25. Petitioner's main grievance is that all the Sridhar articles were not recovered, particularly the jewelries. Full stop. To that effect, a representation was submitted before the police authority is on May 2025, and according to the petitioner, ignoring the same, the police authority submitted a charge sheet before the jurisdictional court. State has submitted a report. The report reflects that the police authority is on being satisfied on conclusion of investigation. On conclusion of investigation, submitted a charge sheet under section 85/316 bracketed 2/117 bracketed 2 of BNS, comma 3 of section 3/4 of DP Act and section 6 of the POXO Act against Manoj Shaw, while under the relevant provisions of BNS and the Dowry Prohibition Act, charge sheet was submitted against Bhola Shaw, Urmila Devi, Rakesh Shaw, Rupa Shaw, and Manvi Shaw alias Jyoti Devi. এখানটা পেয়ে যাবে রিপোর্টে। Full stop. Having considered that the charge sheet was submitted in on or about 23rd of April 2025 before the jurisdictional court, I am of the opinion if the petitioner is aggrieved regarding the act and action of the police authorities, petitioner should approach the jurisdictional court which has taken cognizance of the offence. Full stop. The representation earned to the police authority is where unwarranted aid in view of the fact that a court of law is already in of the issue. Since section 193E9 of the BNSS provides ample opportunity to the petitioner to redress the grievance, I direct the petitioner to approach the learned special court insisting of the issue. Learned special court will assess and ascertain regarding the genuinity of the grievance of the petitioner and pass necessary directions as it deems fit and proper. With the aforesaid observations, WPA 11436 of 2025 is disposed of. Report submitted. We kept in the record. A copy of the report be handed over to the learned advocate appearing for the petitioner.
Number 21.
My lord, I'm appearing for the private respondents.
But I appear in this matter for the writ petitioner.
Yes.
Petitioner is a businessman blood based in Tripura. Now, blood, the respondent number 4 and 5 blood came with a proposal for business deal with the petitioner. Accordingly, the petitioner blood paid rupees 4,95,000 in HDFC Bank at Dom in favor of the blood respondent number 4 and 5. Now, blood, the goods which were supposed to be sent to the petitioner, that was not sent. Despite the fact that the truck was sent to Islampur, that goods were never delivered to the writ petitioner. But the writ petitioner thereafter chased to the respondent number 4 and 5 for quite some time. Since nothing was delivered, the petitioner lodged a complaint before the Tripura police station. Now, that was subsequently transferred to Islampur. Now, we have also made, the writ petitioner has also made a representation to the Barakpur Commissionerate. Nothing has come out. On the contrary, the respondent number 4 and 5.
Not on the last day, it fell from your lordship whether the account has been frozen or not. Now, my latest report is there. I'm just handing it over. Your lordship, kindly see. Account, I have got the report from the bank. That is at page 5. Page 5 is the bank report, Lord. And then the page 5A is the police report. In consonance to the report filed by the bank, the account lot has not been frozen. Bank says that. Your lordship, kindly come at page annexure B, page 5 of my report. In the second, the serial number 2, whether the account has been frozen or not, no. And your lordship, kindly come to the next page 5A of the police report of the IC Islampur.
Which one? Page
5A of my
5A,
report.
yeah.
That is in consonance of the report filed by the bank, concerned bank. Whether your lordship wanted to know whether account has been frozen or not. Account has not been frozen. However, the zero fire was lost blood at Vishalgarh police station. Your lordship, kindly remember it. At Tripura. In consonance to that, 420 section has been drawn up. The investigation is on. Several raids have been made. And now, Lord, kindly come to page
Islampur PS 101. Now the new number.
Yes, oh, new number.
Huh? So you want the police wants to know under which section or bank wants to know under which section?
No, we wanted to know from the bank. Your lordship wanted to know from me whether the bank account, the allegation of the petitioner was that the bank account has been frozen. That we have inquired from the bank. Bank says that no account, the particular account from where he says that rupees 50,000 when he has gone to the particular bank, he came to know that accounts had been frozen. But bank's report says the account has not been frozen. That is the fact of the case, Lord, and that has been stated in page 2 of my report, paragraph
Two
7.
things are there. I've got nothing more.
An investigation is progress section has been drawn for 20.
one thing is, my lord, after refund of 50,000 by the accused, my lord, my bank account was, my lord, said to be frozen. That was number one.
Said, what is your source of information?
Bank said that the
Bank say,
fraudulent.
you don't have any written document.
No, no.
You will get a written document of the.
That is number one. Number two, my lord, Islampur received the complaint from Tripura. My lord, that was received by the my lord,
Other case has been registered 101 of 2025.
my lord, kindly see page,
3rd of February.
yes, kindly see page 106 once. My lord, kindly see.
And
page
there is a
100.
long story, my lord, which has been stated in the police report, paragraph 6 and 7, your lordship.
Case 106, what is there?
6 and 7, your lordship, can you
106, your
see?
lordship, the
Same, particularly paragraph number 7 of my report.
Yes, what?
Islampur police station at the bottom. Islampur police station received the complaint from Tripura and my lord, started an investigation. What is the fate of the investigation? That is the my lord, that is my
That you have got. That is second point you have got to go over there, sir. I will not do that. There is a statutory provision now. After 90 days, yes, you tell me.
Only
this
one.
is not a case where High Court will exercise 226.
No, but
420 case.
Police is
You
appearing.
unnecessary.
Not only thing, not kindly.
There is no fiction involved.
No,
You are creating fiction over here.
Only one thing, let kindly appreciate. Let police.
I have appreciated much, sir. You are at the doorstep. You have got all the release.
Let
Once it was there, that his account has been
that I
that has been
police is
clarified by the
inactive.
bank that the
Even
account
after
has not been
registration of the
Now 3 months are over.
right.
In Islampur,
Right.
you go before the jurisdictional court. You see the specific provision under 193.
That's correct.
There is a specific provision that after 90 days, a progress report, you are entitled to a progress
The
report.
report can be called for in the jurisdiction. Your lordship has ample power. Your lordship kindly exercise that power.
That will be opening the floodgates, sir. I will take up the cudgel of all the magistrates of West Bengal.
No, what is the fate of the FIR? That is the only thing, which I.
The fate of the FIR, you have an appropriate provision. If you have an alternative remedy, why under Article 226 I will invoke, sir?
A report may be called for. Not only one thing, a report may be called for.
Why? Report has been called for, report has been given. You came up with an information which is incorrect. You say
that problem is solved. Since my learned friend has submitted one report, that problem is solved. The second problem still.
No, this is not a counter for that. You go make appropriate application, sir. There is a statutory provision. Why should this provision be invoked? Because 3 months is over, you file an application for progress of the learned advocate appearing for the petitioner is aggrieved by the manner in which the investigation of Islampur PS case number 101/25 is progressing. Earlier, a grievance was canvassed that HDFC bank account number, 5A bank account number so and so was informed as frozen to the petitioner. Consequent to which a report was sought for. State has submitted a report. which reflects specifically that the account has not been frozen in connection with Islampur PS case number 101/2024. Full stop. Petitioner is secondly aggrieved. Now, petitioner secondly expresses agony regarding the progress of the investigation. The provisions of section 193 of the BNSS specifically provides that after a period of 90 days, the informant of the de facto complainant is entitled to know the progress of the investigation. In case the petitioner has not been notified, petitioner would approach the learned magistrate for all necessary informations to be furnished by the investigating agency relating to the progress of the investigation as the subject matter of the case. Even if the starting date is taken to be 3rd of February 2025, a period of 90 days have already expired. Accordingly, if the petitioner takes out any appropriate application under the relevant provisions of 193 BNSS, learned magistrate insisting of Islampur PS case number 101/2025 would pass necessary directions under the relevant provision of the BNSS. Learned advocate for the respondent number. Private respondent number 7, 8, and 9 is present and denies and disputes so far as the accusations made in the writ petition is concerned, and reserves the right to canvass the issues at the appropriate stage of the case. Having regard to the observations made above, further pendency of the writ petition is unwarranted. Accordingly, WPA 11454 of 2025 is disposed of. The report submitted be kept with the record. Serve a copy of the report. A copy of the report be handed over to the learned advocate appearing in for the petitioner. Yes. Who is for the yes? Yes, Mr.
There's no demarcation of the property.
So the petitioner is agreed by the fact that there has been interference at the behest of the private respondents while the petitioner intends to repair the dilapidated part of the building. State has submitted a report. Report reflects that the petitioner and the private respondents are co-owners. Co-owners. Full stop. Having
co-shares. They are
so co-owners is the other case.
but not in respect of the building. Not in respect of the building. In respect of the plot. They are co-shares. But I have a separate building.
That is police's contention. I can't help that, sir.
Yes.
Having considered the objection has been raised by the respondent who has a right under the law. Petitioner be well advised to approach the jurisdictional civil court for necessary reliefs. Police authorities would oversee that and no untoward incident takes place because of the strained relationship existing between the petitioner and the private respondent. So, with the aforesaid observations, WPA 11458 of 2025 is disposed of. Report submitted be kept with the record. Copy of the report be handed over to the learned advocate appearing for the petitioner.
My lord, I am appearing for the petitioner. My lord, may kindly takes up page number 47 and 48, your lordship's order first, my lord. If your lordship kindly sees that. Page number 47 and 48, your lordship's own order, my lord, in this case.
Yes, sir.
My lord, your lordship has passed an order in view of Justice Sengupta's order, my lord. Justice Sengupta's order at page number 34. Now, after your lordship's order, page numbers 48A to 48C, my lord, is the learned, my lord, civil court's order. My lord, appointing a special officer. And the learned special officer's report is at 48D and 48E. Now, my lord, admittedly, my lord, the Honorable High Court had directed that the status quo order which was passed in the civil court, which has now become final, that has to be complied with by the police officers. Your lordship, my lord, once again reiterated this fact and indicated that if there was any violations, civil court will appoint a special officer to give a report to that effect. Now, my lord, that has also been done by us. There's a partition wall which has been broken, my lord. Now, my lord, prayer, as far as prayer C is concerned, it is gone. Loknath Baba Pujo, they have done it. Now, my lord, prayer D is my existing and alive prayer, my lord, before your lordship. Your lordship may kindly seize that prayer.
Each one of them, their is made officers.
Page 24.
Of the order of the status so directed by the High Court of Civil and Senior Commission India.
That was the High Court's order at page number 34. That is the judgment of this Honorable High Court.
The order dated equal without thereby restrict the private respondent from conducting any puja.
Yes, that is the direction of the Honorable High Court. Prayer C is gone now, my lord. They have conducted the puja.
Each one of them aimed their subordinate main officers and agents to act upon the
This was the judgment, my lord. Lordship sees once, my lord, Justice Sengupta's order, please.
ये तो कबेकार की चाहिए you are wanting orders implementation, your civil suit is pending.
My civil suit, my lord, being pending, this honorable court, my lord, Lordship kindly sees Justice Sengupta's order once, my lord. The operative portion only I'm beseeching your lordship. Page 34, the entire backdrop was there.
So that backdrop was in the circumstance of that date. When was the order passed?
That was on 2/2024, the judgment was passed. Correct, my lord?
Page 34, my lord.
2024, yes.
Yes, my lord. Now, my lord will kindly seize, my lord, the operative part of that order once.
So for contents, where the writ doesn't lie, sir.
No. Then after that, my lord. Then after that. After that, my lord, your lordship order, my lord, comes into being. At page number 47 and 48.
That order.
That order, my lord, indicates that a special officer will go and see, because that was a direction passed that civil court's order cannot be violated. That your lordship once again, my lord, held.
Report submitted by the state we kept it. So that has been done. What are you wanting now?
Now, my lord, this order, my lord, now, my lord, what is happening is that consistent. Lordship sees my representation once. Lordship sees my representation once.
All of you state. দুটো করে জুনিয়র দিচ্ছে নাকি?
I should be feeling good, my lord. Now, my lord, Lordship kindly sees my representation.
Respondent number 7 was appearing earlier.
Yes, my lord.
Yes.
Where is he?
But he is aware, my lord, that this matter is appearing, my lord. This is a new motion matter.
No, my lord, it was conducted, my lord. It was conducted over there, my lord. We have given a representation to the police also, my lord. Thereafter, the puja was conducted over there, my lord.
So consistently, my lord, blatantly, these orders are being violated.
Appeal court বুঝবে civil suit. Since the civil চলে আসুন এই তো বাজে মামলা আনছে এবার।
No, my lord, that other one will be good, my lord. That other one will leave matter.
Petitioner has informed the police authority is particularly the inspector in charge Krishnanagar police station after the special officer has completed his inspection, be that as it may, since the civil court is already in civil court, since the learned civil judge senior division 3rd court Krishnanagar Nodia is in CC in of TS number 232 of 2022. I am of the opinion that the petitioner in the circumstance is would better ventilate his grievance before the jurisdictional civil court, which is the NCC in of the issue. In case any direction is passed by the civil court, police authority would act in accordance with law. With the aforesaid observations, WPA number 11462 of 2025 is disposed of. Server copies.
I'm deeply grateful.
Who is for the petitioner?
Lordship, I am for the petitioner. Yesterday I was appearing also, Lordship. I am seeking one humble adjournment for accommodation, Lordship. Some important instruction is to be placed before your Lordship. If it will be monthly list of September as your Lordship discussion, then it is okay, Lordship.
Learned advocate appearing for the petitioner prays for an accommodation. State is represented aid list the petition in the monthly list of September 2025 under the same meeting. Chalo. Thank you.
Bow down, Lordship. Obliged.
Next. Tatirao.
Malad, on behalf of the petitioner, Malad, I had inherited some property. Some property I
purchased. For the state, wait for state ke. Oh, you have.
Malad, I purchased some property. Even
you purchase, you have money, you will purchase property.
Cultivation, my lord, of harvesting. The private respondent has cut down my paddies also, my lord, and has been decided 163 was taken into. Thereafter, my lord, several complaints are also made thereafter. My lord, let me allow to have out a cultivation of my paddy and I can cut down.
Yeah. Chulation. Petitioner
can be taken, my lord. The deeds have been enclosed, my lord. All the deeds are enclosed, my lord. Page number 27, page number 45, my lord.
Aims to be a owner of a plot of land where the private respondents are interfering at the time of his cultivation. To that effect, representation was furnished with the police authorities. However, the police authority is refused to act on the same. On the other hand, learned advocate for the respondent number 629 also claims to be owner of the same land where the
My lord, all the deeds are there, my lord.
what are you claiming? Why his land? Why are you then submitting? এই তো রেসপন্ডেন্ট বলছে না আই এম নট আ কোনার দেখো তাহলে কি বলছে কি আমি তো তাই বুঝলাম তারপরে বলছে
There are a lot of deeds into this, my lord.
চলো
It is purchased on my
ডিলার অফিসে গেলে একটা করে ডিট করে দেয় কি বলছি
Can you allow me to cut off the causes, my lord?
Lane advocate appearing for the private respondent and submits that they are also co-owners who are deprived of the usufructs of the property. Full state has submitted a report. The report of the state reflects that the petitioner and the private respondents are co-owners of the property, and there are often hot altercation between the petitioner and the private respondents. Police authorities also received information that there was a scuffle and fighting. Pursuant to which information was furnished before Keshpur police station. Full stop.
Thereafter also several complaints made about it.
Having regard
was
to the nature of the information which was furnished and the right which the petitioner intend to establish. I am of the view petitioner would approach the jurisdictional civil court for necessary remedies. So far as the police authority is concerned, obviously they would assess regarding the incidents of ground reality, particularly that no untoward incident results because of the inimical relationship existing between the petitioner and the
purchased by me. Can they
with the aforesaid of the appeal court with the aforesaid observations WPA 11500 of 2025 is disposed of. Report submitted, be kept in the records. Appeal court, not a fit court for single bench. Both the parties have report both the court.
Well, kindly allow me to have a cultivation on my land which I had.
Appeal court. পরের দিনই গেলে স্টে পেয়ে যাবে অর্ডার দিলে। হ্যাঁ, নেক্সট কে আছে? Who is there?
Hey, Malad, I want to withdraw this case because the respondent with liberty to file a fresh because respondent names are wrongly written, Malad. Kindly allow me to have a correction into that, Malad. Liberty be given to fresh affair. Afresh, Malad. The respondent names are wrongly been is a copy paste done, Malad.
Page 50 key. Where is page 50? No, civil. These are civil orders, na? But he says respondent's name.
Names have been wrongly means copy paste has been.
You are not Sheikh Saidul. No, Jabbar nahi. So who is it? That is wrong to bolche. What are the names? Lane advocate নিয়ে সময় নষ্ট করছে। না
let me make a correction into that. Come out with a fresh mala.
না, it is Sheikh Saidul, Sheikh Roshan, Ranjit Palmal, Muziran Bibi. These are the according to them.
But these respondent names are not there, my lord.
That is why I am saying running. Lane advocate appearing for the petitioner intends to withdraw the present petition and file afresh. Lane advocate for the private respondents as well as the state is present. in view of the prayers so advance. WPA 11525 of 2025 is dismissed as not pressed. Liberty is granted to the petitioner to file afresh.
27. My lord, I am a Bargadar, my lord.
একবার কি হচ্ছে বর্গাদা এটা তো বাজে
My name has already been recorded. I got a
very good. Who is there? State, who is there?
responded, my lord.
Have you served?
On behalf of the state, my lord.
Right.
My lord, yes.
Your junior is not there. You are junior. Yes. Report is there. Yes.
My private respondent disturbing, getting my name to be deleted to get me out of my land, my lord, not to allow me to have an.
But there are many cases.
Hit me, badly injured. One FIR was done.
My lord, this is total nature of dispute is civil. What can police do? I can only lodge the FIR.
Yes.
I can file the charge sheet.
Because my lord,
You are the accused or the complaint?
the petitioner, my lord.
Petitioner is a vague term in the report. Say you are the informant or the accused.
Accused, my lord.
Huh? You are the accused. You have come for quashing over here.
Accused, no, my lord.
কিসের জন্য এসছে তাই জানে না প্রেয়ার
Accused থাকবো, কেন থাকবো? Petitioner, my lord.
আরে petitioner means what? Info complainant, accused.
Complainant, my lord.
My lord, both parties are the blood relative, my lord.
It can be taken at page number 82, my lord.
Authorities to take appropriate steps বলছে এখানে quashing চাইছে. Each one of them as to why the second.
My lord, all the injury reports are there.
আরে in the same prayer, the same breath you are wanting effective investigation, quashing of the investigation. One case effective হয় নাকি ওটা? Confused prayers. কবে হয়েছে 16/5 after 3 months go before the jurisdictional court for getting notice regarding the progress of the investigation. চলে আসুন. Petitioner is aggrieved by the manner in which you are the complainant in
224 FIR.
24,
At
okay.
page number 82, my lord.
ঠিক আছে এখানে আছে কি বললাম which the investigation is progressing in connection with Keshpur PS case number 220 একটু দেখে করে নেবেন তাড়াতাড়ি বলছি তো Keshpur PS case number 224/25 dated 16/5/2025. On the other hand, petitioner submits that he has been falsely implicated in connection with
Our is FIR 225, my lord.
however you are accused there.
In 225, I am the complainant, my lord. 24, they made out me as an accused. That is 78 is.
দাদা উল্টো পাল্টা বলছে
224 আমরা accused তো।
সুভদ্রা বর্দলি
তাহলে 220 আমরা কি এর মধ্যে কোথায় আছে?
দেখো
আসামি তো। Hello, that page number 78.
You tell me who is Subhadra Bardoli?
বর্দলি কে আছে?
পড়ে আসবে কি জ্বালাতন বুঝতে পারছেন তো
কে আছে?
Let's come to the last paragraph of first page of my report, my lord.
Accused, we are accused.
Huh?
In the 224, my lord, we are accused. And in 225, we are the complainant, my lord.
এটাই তো মুশকিল বুঝতে পারছি এতগুলো দিয়েছে কেন ক্রিমিনাল
FIR 224, we have made the
আরে কমপ্লেনেন্ট ইজ সুভদ্রা বর্দলুই হ্যাঁ তো ভেরি সুভদ্রা বর্দলুই আর পার্টি ইন দিস কেস
দেখতে পাচ্ছি না তোমার এখানে it can be taken সুভদ্রা বর্দলুই
হ্যাঁ
sir I'm not finding the name সাধন লিখে সাধন বর্দলুই
আর যত বালিয়ে মামলা করছে নিয়ে
Passover can be given.
Just wow, Passover, sir.
But
Passover, my lord, please.
Subhadra, I'm not getting Sadhana.
This complaint, sir. I'm withdraw a petition. I mean, then I do.
Subhadra is not there in as the accused, my lord.
You cannot choose the complainant is a necessary. 224 complainant is Subhadra Bardoli.
Complainant is Topon.
report to the case.
My lord, top one is there, my lord.
You can say anything, sir. My report says
My lord, kindly be FIR be taken, my lord. At page number 78, my lord. Kindly page number 78 can be taken. The 225 to 4 FIR, my lord. Topon Bardoli has made out a complaint in regard to that. There are
Topon is which respondent.
Topon is a respondent there, my lord.
Which respondent? কোথায় তপন? কোথায় তপন?
My lord, withdraw to file a fresh, my lord.
কিছুই জানে না. Who drafts? Huh? Who drafts doesn't know what is the connection between the petition and the respondent.
There has been some.
Learning advocate aid for the petitioner intends to withdraw the present writ petition and file afresh. State has submitted a report. Let the same be kept with the record. In view of the technicalities involved, petitioner is granted liberty to file afresh. WPA 11534 of 2025 is disposed of. Chalo. Dispose of করে দিয়েছি কোনো চিন্তা নেই. Where is the petitioner? If these are second time, third time matters are being called, so nobody is. চলে আসুন. Petitioner approached the court being aggrieved. অর্ধেক দিন কোর্ট করবে না, কিছু করবে না. Key petitioner being aggrieved by the inaction on the part of the police authorities, particularly as no steps were taken pursuant to the anticipatory bail of the accused persons having been rejected. Further, a prayer was advanced for production of CCTV footage of Kolshi police station. And an additional prayer as to why the provisions of POXO Act has not been added. Full stop. State has submitted a report reflects that police authority is have taken steps. The case has already been sent to the special court. Sent to the special court, and on conclusion of investigation, charge sheet has been submitted before the jurisdictional court. Having considered the steps taken by the police authorities, I am of the view that no interference can be made by this court at this stage. Petitioner, if she is aggrieved by any part of the investigation,
and your lordship kindly direct the police to sit busy over this issue. There is allegations of threatening.
Petitioner, if she is petitioner, if aggrieved by any part of the investigation, would advance necessary prayers before the learned special court insisting of the issue. However, the police authority is who would keep a strict vigil and ensure that since the offence now is under the provisions of the POXO Act, the guidelines and the rules framed therein be strictly adhered. With the aforesaid observations, WPA 11549 of 2025 is disposed of. Report submitted be kept with the records.
Well, I'm appearing on behalf of the petitioner.
I'm appearing for the private
Petitioner
respondent.
is a
I'm
co-sharer
appearing
of
for the state.
the land.
Yes.
Petitioner is a co-sharer of the subject of the land, and private respondent or also the purchase of the land from the another co-sharer. My lord, therefore, the private respondent have filling of the land and start construction over the undivided portion. Therefore, we have filed the civil. We have filed the civil court file, file, file an application for injunction, and the Ladette Civil Court has passed an order for injunction. I'll kindly see page 37, my lord. Page 37, paragraph 2, bottom portion. My lord, may I be permitted to read, my lord?
No, wait.
Of the opinion.
What are you wanting?
Therefore, the order of injunction is
The petitioner carries the status of the
Ladette Trial Court has passed the order of injunction till the disposal of the suit.
The one
court is opinion that it would be proper to the prayer of temporary.
There is a 151 order. One direction. Direction upon the police authorities.
Police, therefore, we have prayed an application before the police authorities, page 45, my lord.
No, before the civil court, direction upon the police authorities. Where is it?
No, my lord.
No direction.
No direction, my
lord. It's an ad interim order of injunction.
Keep the disposal of the suit, my lord. There's ad interim injunction. In the ad interim, there's temporary injunction, my lord.
Temporary injunction.
Temporary injunction till the disposal of the suit.
Maybe the police authorities have to act.
We have already approached before the OC Jamalpur police station, but did not take the OC.
If there is breach of the order, appropriate direction.
Well, kindly direct the OC Jamalpur police station not.
Bali apply করতে হলো।
No, for that appropriate applications are to be made under order 39 and 151 of the CPC. And your lordship, whenever they have approached the police authorities, as I have submitted the report,
petitioner is agreed by the fact that in spite of the civil court having passed order in TS 45 of 2021, wherein a temporary injunction direction was passed. Directing as status quo in respect of nature, character, and position of the suit.
Till the disposal.
The police authority is, on being informed of such order, is not acting in accordance with law. Full stop. State has submitted a report. Report reflects that the police authorities are well aware regarding the nature of the dispute and the pendency of the civil proceedings as well as the order having been passed. Police authorities have also drawn up proceedings under section 126, 135 of the BNSS.
On 2 occasions,
on repeated occasions. Then advocate 8 for the respondent numbers.
Lordship, there were 5 and 6.
5 and 6.
Lordship, only one indulgence. Even though this story has been brought up, the real story is very harsh. Why I am saying these two private respondents, Boidyanath Mishra and Akbar Ali. Now they have purchased the property, and now Akbar Ali has allowed Boidyanath Mishra to perform his rituals as he is a member of the scheduled tribe. So this is the main contention they are trying to stop. This is the inner story now.
The inner story, I don't know. What is the actual story?
No, this is the only reason they have brought up the story of construction. There is no construction. I am submitting on.
Well, kindly see the representation of page 42.
You serve notice to both the parties.
42 and 45. Kindly see.
The glad advocate of the private aid respondent submits that there has been no construction at the site which is a subject matter of complaint of the present petitioner. You have not dealt with the construction in your report.
Lordship,
Full stop. Police in view the learned advocate for the risk. Additionally, it has been submitted on behalf of the private respondent ends that the petitioner has engineered facts to his own convenience for setting the police into action, although the nature of the dispute is a part of the civil court proceedings. Full stop. Having regard to the fact that the civil court has passed an order of temporary injunction and the police authorities are aware regarding the same, police authorities would continue to oversee that there is no untoward incident resulting in from the inevitable
In
relationship.
respect of unauthorized construction, nothing has been reported in this report, but the same remedy lies under 39.
Not be anyone violate, my lord. I place you through judgment of your lordship, my
Kukulam?
The lordship, the inquiring officer in the last line of the first page of the report, the inquiring officer served notice to both parties to obey the learned court order and asked opposite parties not to make any construction over the said disputed land.
Last time, untoward is resulting from the strained relationship existing between the parties. Full stop. Adjournment with the aforesaid observations. WPA 11551 of 2025 is disposed of. Report submitted. We kept it record server.
We are for the state respondent.
Well, a copy of the report will be served.
A copy of the report be handed over to the parties, both the parties. Who is there? Yes.
I beg to appear in this matter for the response.
এই জমি জমার মামলাগুলো অন্য কোর্ট আছে তো এখানে আসছে কেন বুঝতে পারছি না
Status quo order is there, 151 order is there.
তো go order 39 rule 2A now do.
Yes.
Direction was given.
আর কি বলবো চলে আসুন
Direction was given to the.
Lord, I beg to.
Page number 24, my lord.
the violation breach of the order remedy is there be under the
Last paragraph, my lord.
Order is there, my lord.
petitioner is agreed by the petitioner claims that in spite of direction 1 minute
Your lordship, kindly.
wait petitioner claims that in spite of directions passing TS 11 of the AX08 upon the police authorities to act in a particular manner. The police authority is defying the same to the effect. Information you have furnished. Information was furnished to
The BLRO to the, my lord.
where page number which?
Yes. Page number 30 is to BLRO and my lord. Page number 40 is to my lord officer in charge.
To the officer in charge of which police station?
My lord Bashanti police.
To the officer in charge of Bashanti police station. Yes, now what do you want to say?
My lord, in earlier occasion, I have prepared a writ petition where my lord, on similar circumstances, my lord, when my lord, the order is in force, status quo order, as well as my lord, the order directing the police authority to maintain my lord, the status quo order. What private respondent done, my lord, my house was set up on fire. Your lordship passed an order directing the police authority to maintain peaceful tranquility. My lord, in spite of these incidents, my lord, what private respondent done, my lord, the suit was filed, private respondent.
Okay, then what did the
my lord preferred my lord application before the BLRO recorded their
the বাড়িতে আগুন লেগে
taking advantage, my lord, I am not, my lord, on that part.
Criminal case you forget now. Forget why did you start the criminal case?
My part is that, my lord, status quo order should be maintained, my lord. Yes.
That is maintained, my lord.
My lord, one thing. My lord, one thing, your lordship, allow me. I am the opposite party hearing. My lord, he is my brother. The fighting between the two brothers. Mother, some property left. According to my learned friend, by practice and fraud, he has been obtained entire property mother. Ultimately, that matter was settled before the civil court. This is the order of the civil court. Well, I am giving.
That's my domain. Chalo.
And against that order, he preferred a WPA, my lord, land reform that is pending. One civil court matter is pending. Now, my lord, he is taking a different plea.
Last কথাটা বলুন তো
This is the copy of the judgment of the civil court.
I am not interested. As the state has submitted a report reflects a long-standing land dispute existing between the petitioner and the private respondent, and the civil courts be in thick and thin of the matter.
Just for the till disposal,
Shop.
Because if we agree with the order.
Records also reflect that a criminal case being Bashanti PS case number 963 of the 24 was registered for investigation, and subsequently charge sheet has been submitted before the jurisdictional court. Learned advocate for the private respondent in submit the the petitioner by a committee in fraud has taken possession of, is trying to take is trying to establish his right over a property which is being registered at the best of the private respondents, be that as it may, since the civil courts are insisting of the issue, and the criminal court in respect of the incidents complained of are also insisting of the issue. Presumably the police authorities are well aware regarding the ground reality so far as the dispute and difference between the petitioner and the private respondents are concerned. Consequently, the police authority would oversee no breach of the peace and tranquility takes place or any untoward incident and results. So far as establishment of any right, title, and interest is concerned, it would be the civil court which would decide the same.
Well, I'm strongly opposed my unfair contention because this is not the correct position of the law. If we agree,
let me see.
if we agree with the order of the civil court, he ought to prefer.
What are you wanting?
Here, my lord, stating, my lord, the officer in charge, Basanti police station, my lord, shall ensure neither of the party can do any act in connection with the property of the suit, which may tantamount to change in nature, character, and possession of the suit property until further order. So, what I am saying, my lord,
the civil court has passed that.
Yes. Under 151 application, so that this order can be maintained. Only that.
But if we desire to be implement the civil court's order,
with the aforesaid observation, WPAA 11556 of 2025 disposal report submitted with
report maybe, my lord.
Report submit a copy of the report we handed over to both the parties. Yes.
I have given my lord.
Give it. Next
My lord, 31, my lord, I'm appearing.
Yes, 31, what happened?
My lord, it's a humanitarian case, my lord. Petitioners are the aged parents. Petitioners are the aged parents. My lord, there are two representations which are made. The son, my lord, is harassing them. Initially taken 50% of the property. Thereafter, they assaulted them grievously. They've been ousted from the house. This is on humanitarian grounds. I'm beseeching this.
No, what are you wanting?
There are two representations we have made. The document kindly sees pages 32 and 35.
Consider in accordance with law, sir.
That's it, man, and give them some protection. These are aged parents, man. I would not have pressed. They are not able to return back to their house. Son has driven them away.
Then I believe it's a deal.
No, then let him consider necessary steps be taken, my lord, which is in accordance with law, for their at least for their protection.
Petitioner is aggrieved that এগুলো 498 এ হচ্ছে তার পাল্টা এগুলো হচ্ছে
No, there's no 498. Only the son is doing this. We don't have any problem with the daughter-in-law.
হ্যাঁ জানি তো জানি এতদিন কাজ করলাম আর বুঝতে পারবো না একটু petitioner is aggrieved that in spite of informing the police authorities petitioners are aggrieved by the fact that in spite of informing the police authorities no steps are being taken and the you are senior citizen
Yes, I'm senior, both of them,
and the petitioners being senior citizens are suffering because of the act and action of the private respondent number 7 who happen to be the son and the daughter-in-law respectively.
Yes, mainly it's the son, my lord. Mainly it's the son who is doing this.
Yeah, main sub-main is not as a learned advocate for the state. Submit is that the police authority have inquired and found that no cognizable offense has been made out, and as such, in a family feud, has not interfered with the disputes. Be that as it may, I direct that in case the petitioners face further inconvenience, petitioner will file a fresh representation. He will again come to your chamber. File a fresh representation. Petitioner, as a consequently, police authority will ascertain the veracity of the accusation and take steps adhering to the provisions of law. With the aforesaid observations, WPA 11560 of 2025 is disposed of. Sarva copy. Next.
Debrief.
32. Bas, chalo. It is the last matter. Then go to
35.
35.
Up to 30.
Hearing আছে হ্যাঁ আলি ভাই 35 পর্যন্ত থাকতে very good. What is your matter?
The matter is the petition is a carpenter. The thing is happened, my lord. Petition is carried the business. He have all the license. My lord. One fine day, my lord, one civic volunteer along with the neighbor come to the resident of the petitioner.
Without a police report, I can't do anything. Anyway, who is appealing for the state in this matter? আর দাঁড়াচ্ছি না কেন স্টেটের অ্যাডভোকেটরা দুবার তিনবার করে ডাকছি একই মামলা ভাল লাগে আমার মুশকিল হয়ে যায় These matters were all adjourned because of the state advocates not appearing. No, nothing, sir. Not nobody.
Somebody.
New matter.
I'm engaging somebody, a junior. You come, junior. Serve a copy upon him. Call for a report from the concerned owner. So listen, as the petitioner is directed to hand over a copy to Mr. Learned advocate who ordinarily appears on behalf of the state. His appearance may be regularized by the concerned authorities. The learned advocate for the state is directed to call for a report. Which police station, sir? অনির্বাণ দত্ত হচ্ছে এটার নাম দিলেন কোন থানা অফিসার নতুন হাট মুরারিপুর না এটা কি which Mongolkot police station? Mongolkot police station. কি বললাম petition Lane advocate for the state is directed to call for a report from the officer in charge Mongolkot police station in respect of the accusations made in the writ petition. List the writ petition under the heading for orders in the monthly list of August 2025. Yes.
And for the state,
Earning source, only earning source, my lord, his shop that has been ransacked and destroyed by the private respondents in the presence of policemen. And his, my lord, his land was also being taken forcefully by ousting them.
Respondent number 8, during inquiry came to learn that respondent number 8 was purchased.
Order of injunction is also there, that has been extended.
Hey, Anandike, একটু ডাকো তো।
Subsequently, many things happened, my lord. Subsequently, my lord, to withdraw this case, my lord, my son has been heckled and forcefully taken a huge bribe, my lord, to withdraw, pressurizing this to withdraw this case.
Which case?
To withdraw this writ application. My son has been
my lord, this is purely civil in nature, madam. If you lordship kindly see the representation, my lord. If you lordship kindly see the representation, my lord, that page 25, my lord. It will be entertained, my lord, under section 23(5) of the Panchayat Act, my lord.
No,
the competent authority is the and it will be governed by the Panchayat Act, my lord.
This kind of submissions, I have the injunction.
You tell me one thing. Just wait,
my lord.
You tell me one thing. Why have you registered this case under 223? What is this case? Why?
My shop.
What is your name? Atayur Rahman Mullah. What is the respondent's name?
And the respondent's name is, my lord, Amiruddin Mullah.
Sir, you have created your own grave, I am telling you, police. You see over here, come to your report.
My lord.
Bold letter দিয়েছে আবার 1 2 3 4th page.
Yes, my lord.
You see the bold letter.
Yes, my lord. In course of inquiry, my prosecution vide Dholaghat police station NCR, but because my lord, the construction work was, my lord, done, my lord, that's why, my lord, we have initiated
against
Against the private respondent, আমি কি বললাম my lord?
So against them, you have done.
My lord.
So therefore his story receives some corroboration.
But he has given my lord several complaints, my lord.
That's something different.
My lord.
So therefore there is some corroboration.
My lord.
So you have been ransacked, you have been to file your affidavit, file your affidavit, dispose of করছি না রেখে দিচ্ছি হ্যাঁ চলে আসুন. You file this in the form of a short affidavit.
Additional some.
That I don't know. Then you are lingering the case. How can they file affidavit?
My son has
ঠিক আছে আর এটা ফেরত দিয়ে দিন. Learned advocate aid appearing aiming for the petitioner complains that his shop has been in ransacked and subsequently a new construction has been raised violating all orders, including the orders of the civil court. Learned advocate aid for the state has submitted a report. The same is considered by this court. Learned advocate for the respondent numbers.
Respondent 7 to 10.
7 to 10 is present. Having regard, the reports are submitted be returned to the learned advocate appearing for the state. Let the report be submitted in the form of a short affidavit. Affidavit in opposition be filed by the respondent numbers
7 to 10.
7 to 10. Affidavit in reply if by 22nd of August 2025. Affidavit in reply if any be filed by 12th of September 2025. List the writ petition in the monthly list of November 2025 under the heading.
September at least.
কি করে হবে এর মধ্যে
Every day they are Milord. They are
এই রিপোর্টটা ওকে
monthly list of September Milord. I
ঠিক আছে ঠিক আছে
monthly list of September Milord at least. A copy of the report be handed over.
Petition is filed, my lord. Wow.
এই আর কি আছে 34 35 up to 35 sir last nothing more. হ্যাঁ
On the last occasion, they have prayed for time, my lord.
এই
Last
কি
occasion also.
আমি না থাকলে মাই লর্ড কি করবে
Stop,
সেপ্টেম্বর
There is nothing, my lord.
none appears for the petitioner learned advocate aid for the state all of you for the state
For the private respondent, my lord.
learned advocate for the state as well as the private respondent is present. List the writ petition in the monthly list of September 2025 under the heading motion 2. Chalo next 35.
Your Lord, learned advocate, Hybrid Rahman is appealing for the petitioner. He's not well. I'm praying for not this week, Your Lord.
No. Lordship, kindly see this.
Not well এ করব না not well
well
Hybrid Rahman.
কি বলবো আর কি এইভাবে মামলা করে আমার learned advocate aid appearing for the petitioner prays for an accommodation.
Let it be taken up tomorrow, Milord.
এ করবে না এখন আমি বুঝে গেছি আচ্ছা
Everything has been
personal grounds. Mr. Banerjee appears on behalf of the state. List the writ petition in the monthly list of September 2025 under the
report may be taken on record.
হারিয়ে যাবে under the heading motion 2 আর কি আছে বলুন
September.
বলে লিভ ম্যাটার কি আছে আর দুটো দিয়ে দিন বাকি two matters only he'll pronounce your matter is there and the other
the other matter is I'm appearing.
Leave matter anybody appearing you are appearing
I'm appearing
you are appearing state must appear
yes
you are appearing ঠিক আছে 5 মিনিট পর
very well
5 minutes ঠিক আছে করে দাও এই দুটো ম্যাটার rest of the matters release
My lord.
You wait. Let me complete the leave matter. You will take some time. I'll coolly hear your matter.
I will.
Leave matter to the.
My lord, I am appearing for the petitioner, my lord. My lord, over here, my lord, it's quite a serious case, my lord. We still live in a civil society. Your lordship kindly sees what has happened. My lord, 13th of June at about 11:30 p.m., my lord, this particular petitioner was picked up by the Narendrapur police station. My lord, there is one sub-inspector called Shantanu Baid, my lord, with a civic volunteer named Jia. My lord, what they have done, my lord, is that they have severely beaten him up all throughout the night, my lord, by tying his legs, putting chili in his mouth. Lordship kindly sees the pictures, his pictures from pages 24 to 27. Now, what they do, my lord, they take him out of the back gate of Narendrapur police station in the early mornings of 14th of June at about 2 a.m. Then they bring him from the front gate, assault him further, make him say that he is a co-accused person, my lord, in a dacoity case with regard to taking money from a liquor shop, which was registered on the 20th of May 2025, and then produce him on the 15th of June 2025. Now, my lord, since 15th of June, he was taken into. Sorry.
He was arrested when?
I'm giving the dates, my lord, one by one. He was picked up, my lord, from his locality, my lord, by one Shantanu Baid, that is the sub-inspector of my lord, Narendrapur police station.
Give me the dates only now.
Yes, picked up on 13th June 25 at 11:30 p.m.
It is in paragraph 4.
No, I'm giving the dates only. I'm giving the dates.
Yes.
Then after that, put in from the front gate on 14th of June 2025 at 2 a.m.
14th of June.
2 a.m. again brought in from the front gate. Entirety of 14th of June kept in the police station. 15th June produced in connection with a case dated 20th of May 25.
15th of June, what is the case number?
My lord, the case number, I'm telling your lordship, my lord.
Of 2025.
Narendrapur PS 591.
Yes. 20th.
20th May.
Yes, 20th May, correct. This is a dacoity case where the allegations are that some.
Just 1 minute. These are right now not required.
Not required.
On this day, he was produced before which court?
The magistrate court, my first court of production.
Baripur.
Baripur, my lord.
SCGM Baripur.
On that night, he was taken into hospital, my lord, for treatment.
So, there were no injuries in the court. According to you, the injury prior to that?
Yes. Prior to that.
Prior to that.
Yes. And 2.5 lakhs of medical treatment incurred by the family.
No, between 13th
and
15th.
Yes.
Between 13th and 15th.
Yes.
Not 15, 14. Your lordship kindly see the page 6, paragraph 7. Petitioner submits that on 14th June, the petitioner was produced before the land magistrate and was remanded to judicial custody in Baripur Correctional Home.
15, my lord, he was admitted, my lord. To the
14 June or 15 June he was produced.
Produced on 14th June, admitted on 15th June. I just made one mistake here. Sorry, my lord. 14th June, produced. Yes.
So, wrongful detention is not there.
I am not come here for wrongful detention.
Very good. One.
I have come here for twofold prayers.
1 minute, sir.
Sorry.
13th June he was picked up. 14th June produced in before the learned magistrate.
Correct.
According to your instructions, he was assaulted or injuries were inflicted between 13th and 14th.
Intervening night.
Very good. Number 1. Number 2 is this. He was then thereafter remanded to JC or PC?
JC.
Judicial custody.
Correct.
Acha. By the ICJ on 14th.
Yes, my lord.
14th June. Remanded to JC.
Yes.
Very good. Now, thereafter what happened?
15th June, he was taken to jail hospital.
14th night, he was at jail.
Jail custody. His health was deteriorating. His health was deteriorating. He could not eat anything.
Be correct. 14 June, he was in jail custody.
Yes, correct. Absolutely correct.
Not notionally, actually.
Yes, but actually, my lord, actually.
14 June 25, he was sent to jail custody.
Correct.
Admitted to hospital on
15 June. Correct.
25. And thereafter he expired when?
No, he's not expired. He's alive. This is not a case of expiry.
Oh, acha.
He's alive.
Admitted, acha.
That admitted document only one page, page 28.
Oh, it's custodial torture. Why do you say custodial death?
No, that is another case. That will come tomorrow. This is custodial torture case.
Custodial torture.
Yes.
Acha. You were examined by the doctor prior to production before the court?
My lord, we have, my lord, to that extent, my lord, let the state produce the case because we have no instructions of that.
Very good.
This person, my lord, is very scared, my lord.
You were physically produced before the learned ACJM?
Yes.
Your lawyer was there?
My lord, we have to take instructions to that, my lord. We have to take instructions to that. My lord, all my lord, I'm beseeching for my lord.
Wait, sir, I'll come one.
Yes, ma'am. Yes, ma'am.
You have got any medical report of the last?
Yes, my
Where
lord. My lord, first, my lord, one by one, if I can show, my lord, page 24 to 27 is his photographs. Page 28 is the medical information given by the jail hospital. Lordship kindly sees one, my lord. 24 onwards, my lord, we have got all the annexures, one after the other, my lord. This is all primarily relating to his medical only.
Under 12 prisoner has been sent to Barapur Hospital. So, where are you now admitted?
Now I am released on bail. 19th of June, I've been released on bail.
June, you have been released on which date?
19th of June 2025.
You were produced before the court or no?
My lord, that instruction we do not have. But I'm being very. But I'm sorry, my lord, but that instruction we do not have.
So the only document is page 28.
Page 28 and his photographs from page 24 to 27, my lord, which we have.
Afterwards, is digital photographs, not digital photographs.
Pictorial, my lord, photographs.
Date is not reflecting from the photographs.
Very well, my lord. But my lord, this is the scenario, my lord, which is there. He is, my lord, extremely scared, my lord. Your lordship, my lord, if I could only explain, my lord, the situation, all I want, my lord.
Very good. Let me see what Mr. Banerjee has got to say. What a report.
No, Lord, I have not received any report. But Lord, if your Lordship kindly see, my learned friend has just submitted after your Lordship's query that that illegal detention is not asking.
Not there.
But Lordship kindly see the paper B. Kindly see, Lord, trouble to come, Lord, at page 20 of the petition. Prayer B. Issue read or in the nature of mandamus directing the respondents and their main agents and assigns to so cause as to why such illegal detention and or arrest was made in the petitioner without registration of any first information report to their arrest.
So that is because of the 13th June night when I was taken. At that point of time, no FR was there.
It's wrong prayer.
The first
Anyway,
place.
I don't
Second,
need that. No.
assigns so cause as to why the mandatory provisions of detention and or arrest have not been complied with by the respondent police authorities and to file a report to the respect.
But why? I'll tell your lordship. Let them show that they have informed me with the grounds of arrest or even the anything. Let them show that first.
So D is required. D.
Yes, I have seen. Investigation transferred for torturing and custodial torture and something like that.
You submit a report, ladies.
My lord, I will come with the report.
Report which will enclose the entry of the jail.
Yes, absolutely.
The register of the jail where the accused is being taken from PC to JC.
JC and Lord, the thereafter hospital and
Hospital is afterwards, sir.
Afterwards.
Because injury, if it is there,
That is on 14th June.
that they claim.
14th June.
Because page I would not have, but page 28 itself reflects, if this is a jail document, page 28, his condition deteriorated.
Life-saving measure is also written, my lord.
Page 28.
Yes,
This is a government document.
But the reason for deterioration,
that is will be in the jail register itself when he's been taken. Chole ashun. I have Mr. Mukherjee, learned and advocate appearing for the petitioner.
I'm sorry, Milord,
Yes.
Only your lordship kindly record one thing.
Yes.
Because the person which who has been engaged as junior, Sujitya, you do not know. Lordship kindly record that. Instead of Milord, I have engaged another. My choice. Lordship kindly. Yes. ভাই দাঁড়াও না বলে
কি বললাম?
রেকর্ড করে দেবে
appearing for the petitioner, একজনই আছে petitioner, claims that the petitioner has been subjected to physical torture after he was picked up and detained by Narendrapur police station by a sub-inspector of police attached to the said police station, and thereafter arrested in connection with Narendrapur PS case number 591/25 dated 20th May 2025. Full stop. According to the learned advocate, the petitioner was produced before the court on 14th of June 2025, and thereafter he has been sent. And thereafter the jail records reflect that on 15th June 2025, as a life-saving measure, the petitioner was sent to Baruipur Sub-Divisional Hospital. Full stop. He is still under treatment.
Yes, ma'am. Yes.
Petitioner is still under treatment after he was granted bail on 19th of June 2025. The document dated 15/6/2025, and the accusations made by the petitioner prima facie he calls for this court to at least call for a report from the appropriate authorities. Accordingly, Mr. Banerjee, learned additional government in pleader, is assisted by Mr.
Diptendu Narayan Banerjee and Manos Sadhu.
ওই দিয়ে নামগুলো learned advocate Mr. Diptendu
Narayan Banerjee and Manos Sadhu.
Sadhu, learned advocates, whose appointment has to be regularized.
There. Because Sujit Chatterjee.
The associates who are assisting Mr. Banerjee, their appointment may be regularized by the concerned authorities. Full stop. The report of the state would include all the documents of the police station as well as the jail authority is. The case diary be also produced before the court. List the writ petition under the heading for orders on কবে দেবো একটু তাড়াতাড়ি শুনতে হবে তো আজকে 22 তারিখ না এসব তো করতে পারবো না যা অবস্থা
করতে পারবো না
on 29th of July 2025 for 29th of July 2025 at 4 PM করে দিন for orders এই রাখবে 4 PM করে 29 July ঠিক আছে চলো you take your seat, let him complete his arguments, state his arguments. Thereafter, if you feel you can start today because he'll take a long time, I believe. Or I will fix another date for your argument. You just sit and listen to what the state argues. This side, come. ভালো একটা জায়গা করে দাও, উনি তো লিটিগেন্ট তো, এটা এগিয়ে নিয়ে আসুক, চেয়ারটা শুনতে পাবে যাতে party to the litigation appearing in person. Please, you will be doing your case on your own definitely.
My lord, this is a case, my lord, where
এটা দাও ওই কম্পাইলেশনটা
compilation was there.
You are assisting Mr. Banerjee. আচ্ছা। Yes.
My lord, this is a case, my lord, no recapitulation is not required perhaps. My lord's memory is well aware of the fact, my lord. I have in my kindly take some my index, my lord. In the compilation, I have mentioned the judgment cited there on up to CL number 8. My lord, the next judgment I intend to cite, my lord, is the CL number 9, that is 2001, volume 6, SCC 181.
Yes.
Lord, during the course of argument, Mr. Bandyopadhyay submitted or raised a question that in a single incident, 3 FIRs were lost. In a single incident is one, admittedly a person died, and 3 FIRs were lost. Why this type of situation arose? Because the single FIR may suffice. But I am not standing on the word, I am not saying that the 3 FIRs were needed or the single FIR can suffice or 3 were not. But the proposition of law says, my lord, also well aware. The famous case of TT Antony, my lord. I will start from paragraph number 19, it's page 15 thereof. Paragraph number 19, my lord.
19, but you in your index you have referred to 17 and 18.
17, 18, start from 17 and 18. But I will skip over there, my lord. I can start from there, but just a mere time consuming.
Amen. Yes.
I can start from 17 also. Lord.
No, 19 you start.
Right. Well, those are the 154, the scope of 154, the parameters or how the FIR will be lost. That parameters have been laid down in 18, 17 and 18. Now the 19 says, the scheme of CRPC is that an officer in charge of a police station has to commence investigation as provided in section 156 or 157 on the basis of entry of the first information report. On coming to know the commission of cognizable offence, on completion of investigation and the basis of evidence collected, he has to form an opinion under 116 and 70, or as the case may be, and forward the report to the magistrate on 73(2). However, even after filing of such report, if he comes into possession of further information material, he need not register a fresh FIR. He is empowered to make further investigation normally with the leave of the court, and where during further investigation he collects further evidence, oral or documentary, he is obliged to forward the same with one or more further reports. This is the important subsection of 8 of section 173. Para 20. From the above discussion, it follows that under the scheme of the provisions of 154, 55, 156 up to 173 CRPC, only the earliest of the FIR first information report in regard to the commission of cognizable offence satisfies the requirement of section 154. Thus, there can be no second FIR, and consequently, there can be no fresh investigation on receipt of every subsequent information in respect of the same cognizable offence or the same occurrence or incident giving rise to one or more cognizable offences. On receipt of the information about a cognizable offence or an incident giving rise to cognizable offences, and on entering the FIR in the station house diary, the officer in charge of the police station has to investigate not merely the cognizable offence reported in the FIR, but also the connected offences found to have been committed in the course of same transaction or same occurrence, and file one or more reports provided section 173. My lord, I intend to submit, my lord, the elaboration here perhaps says, after receiving the information of a single occurrence, 3 FIRs were initiated. One by the relative of the deceased, one by the friend of the deceased, and another by the OC himself. Other 2 has been dropped, and the another has continued. that culminated in Lord FRFM, then FRF, and thereafter further investigations were directed. But
So those were FIRs registered.
3 FIRs registers.
So those FIRs which were registered, you closed that at which stage?
After taking the evidence, after recording the evidences, statements, after recording the statements.
Full investigation carried out.
Full investigation carried out.
In all the 3 cases.
In all the 3 cases.
My lord.
Hmm.
The first FIR was
Don't
lodged-
intervene. Let him place his case. You jot down the points. You may be in a better position to submit. That is why I have called you actually. Otherwise, I would not have called you.
In 3 cases, all the 3 cases, statements were recorded.
No. And 173 reports were submitted before the court.
Report submitted before the court. After that, them had been withdrawn.
2 of them withdrawn.
One by the state and one by the defendant.
Withdrawn by the state.
By the state. Because the state means below the complainant, the OC was the complainant, the respondent was
no, withdrawn means dropped or withdrawn. 321.
321.
321.
321.
Where is that page, document?
5 I have to inquire. I have the copy. I have the copy, Lord.
Where is that 321? That is not a part and parcel of these records.
Petition. That is, one is 23, one is 24, or 25. 3 FIRs. 25 has been withdrawn under 321. FIR 325. 20, my lord, stand corrected. 23 and 24 withdrawn. 23 by the respondent number 10, that has been withdrawn.
You were aware regarding this? I also. Because this argument is first time coming before this court. This was not argued.
My lord, I in the opposition, in the opposition filed by the state, it has been there. It is there.
It is there.
My lord. Perhaps not in a bold manner, but it has been touched that the 2 of the FIRs, 23 and 24.
You have enclosed the 321 order passed by the state in this?
No, in the opposition.
In the opposition?
No. I have the lord.
Let me see the 321.
25. बिल्कुल सबগুলো দিকে আমাকে দেখে নিচ্ছি দেখো আরো আছে দেখে নিচ্ছি I have the status report. Can I go to a lot similar? I have the status report. The order I have to search it out from this Himalayans. I have the status report.
When was that 321 order passed and allowed by the court?
It's
when did the government take a decision to withdraw the prosecution?
in 2010. 10th of October 2010.
10th of October
2010.
2010.
Incident of 14th of February 2010. 10th of October 2010.
And when was it placed before the court?
Immediately thereafter.
In October 2010.
My status report dated October says Jongipada PS case number 23 and 24 under section such and such with arm such and such being number such and such is withdrawn on 4/7/13 by learned CGM Sirampur. On 10 we took the decision. It was submitted before the court immediately and the court was pleased to pass an order for withdrawal of the same or 4/7/13. The 23, case number 23, where the complainant is the respondent number 10 himself, that has been withdrawn on 4/7/13.
Complaint means this petitioner.
No, the respondent number 10.
The respondent number.
10 herein. The OC of the.
No, he is not the complainant in this case.
In 23 is the complainant.
This is case number what?
Is he arising out of case number 25?
And so they are an individual lodged the complaint.
They are CFI.
So this has got nothing to do with those two.
Oh, I just indicate because of the fact Mr. Bandyopadhyay said the white CFIs were there. I wanted to just indicate that why 3 FIRs were there and subsequently what is the status of the FIRs.
And what is the reason in that order passed by the state?
Well, as because the other FIR is being continued and being reinvestigated.
No, is there any substantial reason over there? As a matter of public policy, this is being.
I have to then search it out. I cannot rightly.
No, you don't have that. Where from are you reading?
From my status report. Status report sent to Hooghly DDI from Lord the GRO Sirampur.
Achha.
From the GRO Sirampur. The status report has been sent to the DDI.
So there must be a government order to that effect. Yes. Presumably there must be.
There must be. Unless that is there, it cannot be placed for withdrawal.
No, I want to know these are then separate grounds. If you say that another, because of pendency of one FIR, this FIR is being withdrawn.
2 FIRs withdrawn.
2 FIRs. No, one is at the instance of the private party or both are at the instance of the government?
One again is by the private party and another by the.
So private party, how in a 302 case, how it withdrew the FIR?
No, we filed a closure report. He did not challenge.
That's a different.
That is on another way.
That's in another way. So there a complete investigation was on.
And here also we took examinations, not examination, the statements were recorded.
No, just tell me now the 321 order or communication or government decision which was taken for withdrawal from prosecution. This was during the pendency of the investigation or after the investigation?
After the investigation.
After the investigation, why do you take 321?
The order of the government, my lord.
If an investigation is there, there is requirement of 321. If investigation is not there,
after my limited knowledge says, my lord, after the investigation completed, they found that FIR number 25 of 10 is running. That is being reinvestigated by the order of the learned court.
But if a final report has been submitted,
no, final report submitted 23. Sorry, 25.
No, the one in which government decided to file 321.
Yes.
The 321 application which was filed before the court was during the course of investigation. That October 2010 was when investigation was continuing or investigation concluded.
I have to specifically search for that. My lord.
Search for that also.
I have to specifically search for that.
I know this matter. My lord, the first case was registered by OC, case number 23. Second case was registered, complaint was given by the injured persons who sustained bomb injury, arrow injury, etc. Those two cases were investigated and charge sheet was submitted. But at that time, the opposition, now who are in government, at that time they were in opposition. When they came in government, they withdrawn these two cases, the first two cases, 23 and 24. But case number 25, where the allegation is against me, against OC, without any provocation, he fired one person.
That is that we are dealing with. That's a
case, that case was going on again and again.
No, this 321, if you know, then October 2010, he says that the withdrawal was done.
Permission of withdrawal was granted.
All the case, investigation of all the cases were going
on.
Yes, my lord.
And then when was the 321 decision taken off?
13 in the year of 2013.
Not in the year 2010.
No.
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 Search Mr. Shamantu properly. He is well acquainted, I believe.
My record from the GRO says
GRO
application was filed on 10 and the order was passed in 13. Order passed on 4/7/13. Application taken out on 10/12/2010.
You ask the officers to give the documents, relevant documents.
I will.
Because he may be correct, because all on a sudden you cannot close a case when the 3 wrongly gone. Nobody has come for quashing of the proceedings.
Yes.
Nobody came for quashing of the proceedings.
2 dropped.
Now the 3 investigations, until and unless once you register the FIR, you have got until and unless High Court interferes, the police authorities have to take the investigation to a logical conclusion. So they have got to submit 173 in any form or the other, whether a case is made out, whether a case is not made out. Now, if the state decides at that stage to withdraw, there's a state's prerogative.
Under 320.
Whether 321 order is correct or not, that is not in front of me right now.
But my God, these 2 cases are registered first. Case number 23, 24. It was these two cases are registered first, and
but they don't exist as on date, and that is not subject matter of challenge before me. This is just an information which he is sharing, because that has got until and unless somebody challenges those, I cannot suo moto enter into that zone. Try to appreciate. Why should I have got my limited jurisdiction. I cannot. Somebody has got to challenge that. That withdrawal order has not been challenged before me.
No.
So it's the state's prerogative. Obviously, the de facto complainant has a right. That's a different issue totally. But before me, that issue is not there. Yes. Before me, the only issue is regarding the acceptance of the final report in this particular case, one case only. So unnecessarily dealing with that is not very important. But what is more important, which has the flavor, is that over here that at least the state did not think it fit and proper as a matter of public policy to prosecute.
But
321 is always for public policy.
Yes.
Now, it is a de facto complainant who can challenge and say it is not for public policy.
Yes, because he is the worst sufferer.
But when state has passed an order and that has remained unchallenged, presumably this presumption carries with that
is finality.
Public policy, but as a matter of public policy, state decided for varied reasons, sir. Sure, Tarpar. But then TT Anthony, you want to place now? Is your argument that since those 2 FIRs
merged with this,
how is the merger taking? Did not merge.
Officially or technically did not merge, but the
no, you can only
position will not says will not, because the 161 statements were recorded in all the cases. In some of the cases, the accused were those persons. Take the first one, that is 23. In 23, there were several accused persons who adduced under 161 in 25 and 24.
No,
they have the common interest conflict interest.
If the subject matter is same,
yes,
regarding the incident subject matter is same. Now, my question is that why are you relying upon TT Anthony? Because 321 as such, you cannot say right now, no FIR is there, no case is there right now.
No.
Where is the scope of arguing now? This is the case of second FIR.
No.
And we are at a stage when the police authorities have already submitted their final report.
In one case.
This is the only case, sir.
No, I am on the proposition. There were 3 cases. During the course of investigation, during the pendency of the investigation, 2 of them has been dropped. One by the state under 321. In another, after completion of investigation, it has been dropped. They have not challenged. It reached its finality. Then the third one came. Third one has been directed to be investigated thrice. That has been done. Now, I intend to.
What is your point on TT Anthony?
T.T. Antony, because the petitioner is.
So that stage has gone. Today we are not at the FIR stage. We are not at the FIR stage today. Irrespective of all the cases, we are not at the FIR stage. Now, after those two cases have made it say unchallenged way of closure. Then where is T.T. Antony giving you advantage? You cannot say since 321 was granted in that case. This case I am entitled to have a similar verdict, sir. Can you say that?
No, I am not on that. I am saying, Lord.
Then you have got to have an order under 321 over here.
320 under 321 one has been dragged.
That see, those cases very badly dealt with actually. No provision of law has been followed. It could a problem. The thing is this. You are relying upon T.T. Antony. T.T. Antony says that on the self-same subject matter, if there are two FIRs, the second in time should be quashed. Provided there are certain provisos, subsequent judgments are there also. It's not that technically, if it is like that, a telephonic information was given.
That
and
is taken into account.
So whatever it is, those are separate. Now, let me accept your proposition totally. But today we are not at the stage of investigation. Other two cases automatically has made their end. Why are you bringing those cases? Then I have got to go into those cases.
No, I intend to submit as because, my lord, if I were or we were in those stages, what would have been the proposition? If we were in,
there is unnecessary, then I have got to return back to those stages, sir. I don't
my
think,
duty being
I don't think you are inviting that.
No, being an officer of the court, my duty is to make it crystal clear, everything, to my level best. But the next one, my lord.
Take your seat, take your seat.
The next one, my lord, kindly ignore that one, my lord. I subsequently I read out, my lord, it is not relevant, my lord. The serial number 11, my lord. 1975 2 SCC.
10 you are not placing.
No, my lord. When I am not placing. Next one is 1975 2 SCC 557. Well, it's with regard to during the course of hearing by the petitioner, a question perhaps fallen from your lordship regarding the scope of the writ court. With regard to the proposition of interference to the situation where investigation has been directed twice. The police, the SDPO investigated once. Then thereafter there was in order of further investigation. The DDI, the district DDI investigated. Thereafter this DIG CID investigated. And third time we could not come to a conclusion. In all the situations, we could not made out a strong and stable case where we can go to trial. Your lordship's query was that whether the writ court can enter into that zone. The scope of the writ court. Lord, I intend to cite, Lord, the place, paragraph number 21 at page 6. Internal page 6, Lord.
Yes.
The lordship got it, Lord. The scope of Article 226 in dealing with departmental inquiries has come up before this court. Two propositions were laid down by this court in the state of AP and versus C. Ram Rao. First, there is no warrant for the view that in considering whether a public officer is guilty of misconduct charged against him, the rule followed the criminal trials that an offence is not established unless proved by the evidence beyond reasonable doubt to the satisfaction of the court must be applied. If that rule be not applied by a domestic tribunal of inquiry, the High Court in a petition under Article 226 of the Constitution of India is not competent to declare the order of the authorities holding a departmental inquiry valid. Well, pausing here for a moment. Though it's regard to the departmental inquiry, my lord, I will invite your lordship to look into the facts and circumstances of the case where, my lord, there were consistently order of reinvestigations were there. We investigated into same. But here, being officer of the court, I am neither defending the respondent number 10 nor the petitioner nothing. But I, being the investigating authority, my submission would be, the basic submission would be, I have done my job in proper form and manner. What I have done, that the best way that could be done. Beyond that, nothing could be done. But then, my lord, the court is not a court of appeal under Article 26 over the decision of the authorities holding a departmental inquiry against the public servant. The court is concerned to determine whether the inquiry held by the authority competent in that behalf and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. Second, where there is some evidence which the authority entrusted with a duty to hold the inquiry has accepted, and which the evidence may reasonably support the conclusion that the delinquent officer is guilty of charges. It is not the function of the High Court to review the evidence and to arrive at an independent finding on the evidence. The High Court may interfere where the departmental authorities have held the proceeding against the delinquent in a manner inconsistent with the rules of natural justice, where the authorities have disabled themselves from reaching a fair decision by some consideration extraneous to the evidence and the merits of the case, by allowing themselves to be influenced by the irrelevant consideration, or where the conclusion of the very face of it is wholly arbitrary and capricious, that no reasonable person could ever have arrived at that conclusion. The departmental authorities are, if the inquiry is otherwise properly held, the sole judges of fact. If there is some legal evidences on which their findings can be based, the adequacy or reliability of the evidence is not a matter which can be permitted to be canvassed before the High Court in a proceeding for a writ under Article 226. Next, again, this court in Railway Board versus such and such said High Court does not interfere with the conclusion of the disciplinary authority unless finding is not supported by any evidence, or it can be said that no reasonable person could have reached such a finding. In such and such case, the court held that the High Court exceeds its power with interfering with the findings of the disciplinary authority on the charge that the respondent was instrumental in compelling the shutdown of the air compressor report such and such. This court had the inquiry committee felt that the evidence of two persons and the respondent had a group of strikes and compelled. But coming to the last portion of the paragraph starts with this court. This court held that the conclusion reached by the disciplinary authority should prevail and the High Court should not have interfered with the conclusion. And Millard, the para 24, 25, 26 onward, well, on this score, when a authority, here the authority, well, actually, in our case, Millard, it's a court. It's like that court below. The court below has reached into a conclusion after Millard looking into the FIR, the 161 statement, the 164 statement, and all the ocular evidences, medical evidences, all those were there before the court. Medical board was formed, and after looking into those, the order for further investigation there for thrice. My humble submission will be, my lord, before your lordship, that this court, with deepest of respect, my lord, this court sitting under Article 226, perhaps has no jurisdiction. Perhaps, my lord, my limited knowledge says this, my lord, has no scope to interfere with this, unless otherwise it is legally not correct. And my respect to submission will be, my lord, we have entertained all the issues, looked up into all the issues, and thereafter we come to the conclusion. But then kindly takes up the next judgment, CL number 12, 2024, volume 4 SCC, page 208. My lord, this one I intend to rely as because, my lord, during the course of hearing, it has fallen from your lordship that what will be the extent of a report of ballistic inquiry, whether this report have any impact upon this or not, my lord. On that score, my lord, I intend to rely para 34 of the judgment. Lord, it's on page 13, internal page 13.
Paragraph 34.
34, my lord. Page 220 of the cited dismissals.
Thus, what can be reduced?
My lord. Get full to lordship.
Yes.
Thus, what can be deduced from the above is that by itself, non-recovery of the weapon of crime would not be fatal to the prosecution case. When there is non-recovery, there would be no question of linking the empty cartridge and the pellets seized during investigation with the weapon allegedly used in the crime. Obtaining the ballistic report and examination of the ballistic expert is again not a inflexible rule. It is not that in each and every case where the death of a victim is due to gunshot injury, that opinion of the ballistic expert should be obtained and the expert be examined. When there is direct evidence, eyewitness account which is found to be credible, omission to obtain ballistic report and non-examination of ballistic expert may not be fatal to the prosecution case, but if the evidence tendered, including that of eyewitness, do not inspire confidence or suffer from glaring inconsistencies, coupled with the omission to examine material witnesses, the omission to seek ballistic opinion and examination of the ballistic expert may be fatal to the prosecution case. But I find that this paragraph diverges in two different ways. One is saying the eyewitnesses can be given weightage, and the another part is saying the eyewitnesses cannot be given a weightage. But if the eyewitnesses are given weightage, then my lord, I will be in a difficult place. Because my lord, I say the sum of the eyewitnesses in under 161 says it has been a gunshot injury, but who has fired this, we have not seen. Some says it has been taken out from the west side. Some say it has been pulled out from the socks. There are difference of statements. So, my lord, we opted for the ballistic. The ballistic says otherwise. Lord, I will, my lord, during the course of hearing, my lord, I will submit before your lordship the reports of the ballistics. My lord, there are huge and gulf differences. From in somewhere it has been stated the gunshot injury consists of bore is something. In the other report, the bore is different. In other report, the third bore measurement is came out. And we are in a dilemma, which one will be the actual state of affairs. Next, kindly takes up serial number 13, 2010-10, volume 10 SCC 259, paragraph number 39, 40 and 60. Internal page 21.
Thus the position of law.
Thus the position of law. Grateful to you. Thus the position of law in case where there is a contradiction between medical evidence and ocular evidence can be crystallized to the effect that though the ocular testimony of a witness has greater evidentiary value vis-a-vis medical evidence, when medical evidence makes the ocular testimony improbable, that becomes a relevant factor in the process of evaluation of evidence. However, where the medical evidence goes so far, it completely rules out all possibilities of ocular evidence being true. The ocular evidence may be disbelieved. I know there is a judgment delivered by your lordship where perhaps contrary to this proposition. There is a judgment, I am aware of that judgment, but that is contrary to this proposition. So, your lordship perhaps indicated that the ocular evidences cannot be ruled out. But this proposition I found, this is also a judgment, it has not been turned down till date, my lord. My lord, the next paragraph, paragraph 40. In the instant case as referred to here and above, a very large number of assailants attacked one person. Thus, the witness cannot be able to state as to how many injuries and what manner the same had been caused by the accused. In such a fact situation, discrepancy in medical evidence and ocular evidence is bound to occur. However, it cannot be tilt the balance in favor of the appellants. So kindly then directly come to paragraph number 60. That is the concluding portion, my lord, in view of the above, the last page of the judgments. The last part, one page. In view of the, have your lordship got it, my lord? In view of the above, we are of the view that the instance case does not present special feature warranting review of the impugned judgment. Thus, there is no cogent reason to interfere with the impugned judgment and such by the High Court. The appeals lack merit and accordingly dismissed. My lord, here, my lord, after considering the every aspect, the Honorable Court has held that the ocular can be ruled out and the medical and the plastic will be given preference. My lord, the next one I intend to submit, my lord.
But you see over here,
My lord.
this paragraph 39, you
39.
again come. Slowly read that.
My lord.
Thus, the position of law in cases where there is a contradiction between medical and ocular evidence can be crystallized to the effect, up to this one, that though the ocular testimony of a witness has greater evidentiary value vis-a-vis medical evidence, this is the main principle.
My lord.
When medical evidence makes the ocular testimony improbable, that becomes a relevant factor in the process of evaluation of evidence.
My lord.
It's only an evaluation of evidence that's left to the court of law to decide. However, where the medical evidence goes so far, this is where you are on, only to this extent,
Yes.
that it completely rules out all possibility of the ocular evidence.
Being true.
You understand? You are only on this part, on this part.
My lord. Grateful to Allah. I am harping only that part only. That
Only, But this is the principle is the same. That wherever there is a difference between ocular evidence and medical evidence, ocular evidence will dominate the situation and medical evidence accordingly you have got to ignore. But where there is a cases of improbability that the medical evidence is such that it rules out that such an incident cannot happen.
Can be ruled out.
Or then the ocular evidence has to be ruled out.
Yes. Well, in our case, perhaps this situation,
we'll see to that how you
track is going perhaps towards that. But next one, my lord. Uh, 2024 SC online SC 2643. Paragraph number, my lord, 31, 32, and 33. Internal page, my lord, 8.
Yes.
In the present case, though the trial judge rejected the application, the High Court has ordered further investigation concerning the fact that we are inclined to set aside the order of the High Court on merits necessary to discuss the issue of the jurisdiction. Ultimately, the contextual facts that the attendant circumstances have to be singularly evaluated and analyzed to decide the needfulness of further investigation to unravel the truth and mete out the justice to the parties. The cases are cited where fresh materials come to light which would implicate persons not previously accused for absolve persons already accused or where it comes to the notice of the investigating agency that a person already accused of an offense has a good alibi, it may be the duty of the investigating agency to investigate the genuineness of the same and submit a report to the court. Next. However, the further investigation cannot be permitted to do a finishing and the roving inquiry when the police has already filed a charge sheet and the very application of further investigation in this case. Respondent number 1 has not whispered about anything new in evidence as is now sought to be averred in the application. There must be some reasonable basis which should trigger the application for further investigation so that the court is able to arrive at a satisfaction that ends of justice require the ordering or permitting of further investigation. But the Qureshi judgment has been cited. But here, my lord, I intend to submit, my argument will be that the case made out by the petitioner in the FIR has been investigated and the state has come to a logical conclusion, not once, thrice. The first one, they prayed for further investigation, the learned court was pleased to grant. The second one, they prayed for further investigation, that was after the SDPO is shifted to the DDI. Thereafter it shifted to the CID ADG. Now, my lord, if in a practical field, my lord, if we visualize, my lord, the incident of 2010 is 2025. If the things are juxtaposed in their places, we cannot be able to perhaps, whatever the agency may be, whatever the situation may be, my lord, perhaps we will not be able to juxtapose or assemble them in their place or in their order. Perhaps there will be no situation that it could be investigated on that score or in that score.
Are your 3 investigations on the same tune? You concluded
in the same tune.
In the same tune.
In the 161.
Same tune means your final opinion.
No, first one was not formed any opinion. After recording the taking with evidences for 161 and 161, it has been dropped. The government decided under 321.
No, not first case. This case. Thrice you said there are investigation.
No, I was not able to understand.
The first time when you submitted 173 over there.
First, it was thrice. It came out in a triplicate manner. First one is FRF.
Mistake of fact.
Mistake of fact. First, then thereafter the same.
What was the reason for mistake of fact?
No. এটা বলছেন না my lord.
Anyway, you complete this part. Otherwise, we will not be reaching towards anything. You keep these questions in mind.
I will answer to it.
There are 3 parts. According to you, thrice this report has been finally submitted before
one
the
is mistake of facts.
Mistake of fact. Second time for
same and
mistake of fact.
Third is the
ballistic opinion, which was the foundation for arriving that this incident could not have been done at the behest of the
incident took place, but we cannot make anybody
responsible for that.
Liable for this.
This is your third one.
Third one.
The earlier 2 ones, you find out why mistake of fact was. Carry on.
My lord, this judgment ends here, my lord. Next, my lord, the TL number 15. 1983, volume 2, SCC 174. One second, my lord. Paragraph number 13, 14. 13, 14, 15, my lord. I was submitting before lordship regarding the evidentiary value of the medical evidences. But the last 2 pages of the judgment.
এই পাতা মিস হয়ে গেছে 13 14
My lord, 1983 to a
হ্যাঁ তো 9 and 10 therefore 18 19 চলে এসছে
no, there is no 18, 19. Its end is in for 15.
করেছি জয়ন্তপুর সামন্ত এসসিসি অনলাইন 9 10
9, 10.
from the
10, then 11.
no 11 নেই then the 18th page I don't know where from it is coming. You take this, see if I am wrong.
No, my lord, there no question of your lordship being wrong, my lord. The difficulty that I am holding the soft copy.
So very good. This is 1961, na?
1983.
1983.
My lord,
1983 you have completed already.
No, 1983 to SCC.
You have not
24.
you have not completed that.
No, I have completed 2024 SCC online.
Acha 1983. Paragraph 13.
13, my lord.
Yes.
It starts with ordinarily. Ordinarily, the value of medical evidences is only corroborative. It proves that the injury could have been caused in the manner alleged and nothing more. The use which the defense can make the medical evidence is to prove that the injury could not possibly have been caused in the manner alleged and thereby desecrate the eyewitnesses. Unless, however, the medical evidences in its turn goes so far that it completely rules out all possibilities or whatsoever of injuries taking place in the manner alleged by eyewitnesses. The testimony of eyewitnesses cannot be thrown out on the ground of alleged inconsistency between it and the medical evidences. The next paragraph, 14. The main ground on which the evidence of eyewitnesses have been discarded by the sessions judge as observed earlier was that the medical evidence believed the prosecution case. The High Court, in our opinion, was fully justified in coming to the conclusion that medical evidence did not believe the prosecution case, rather it was in support of the prosecution case. In view of that, the High Court took about the medical evidence, it proceeded to consider the worth of the evidence of the eyewitness. In the opinion of the High Court, all the 3 witnesses were possible witnesses and their presence was quite natural. The PW4, being the widow of the deceased, was likely to be present at home, and all these the circumstances have been. The next page, kindly come to the concluding portion of paragraph number 14. Next page, my lord. It says page 181. It has given cogent reason for relying on testimony of 3 witnesses. No exception, in our opinion, can be taken to the appraisal of the evidence made by the High Court. It is not necessary to repeat those reasons in great detail. In the opinion of the High Court, the conclusion arrived at by the sessions judge was not a possible conclusion on the basis of the material on the record. On these findings, the High Court set aside the order of acquittal and convicted the appellant, such and such. The petitioner was, however, but here, my lord, my arguments is clear, my lord. Here, my lord, the medical evidences, the value of the medical evidences, we have taken care of that, and weighing that value, we have come to the conclusion. But for this reason, I intend to submit this. The next one, my lord, 1961 SCC online SC21, serial number 16, my lord, 16.
Yes, paragraph.
Paragraph, my lord, 8 onward. It's a decision of the full bench. Your lordship will aware perhaps of this, my lord. Internal page number 5, my lord. the bottom. There can be no doubt that the fundamental right guaranteed by Article 32(1), it's before the Honorable Supreme Court, our will be Article 26, a very important safeguard to the protection of the fundamental rights of the citizen. And as a result of the said guarantee, this court has been entrusted with the solemn task of upholding the fundamental rights of the citizen of this country. The fundamental rights are intended not only to protect individuals' rights, but they are based on high public policy, liberty of the individuals, and the protection of his fundamental rights are very essence of the democratic way of which fundamental rights are very essence of the democratic way of life adopted by the Constitution, and it is privilege and the duty of this court is to uphold those rights. The court would naturally refuse to circumscribe them to curtail them except as provided by the Constitution itself. It is because of the aspect of the matter such and such. In the very first year after the Constitution came into force, this court rejected the preliminary objection raised against the competence of a petition filed under Article 32 on the ground that a matter of orderly procedural petition should first have restored to the High Court under Article 26 and observe that this court in thus constituted the protector and guarantor of the fundamental rights, and it cannot, consistently with the responsibility so laid upon it, refuse to entertain applications seeking protection against infringement of such rights. Thus, the right given to the citizen to move this court by a petition under Article 32 and claim an appropriate writ against the unconstitutional infringement of this fundamental right itself is a matter of fundamental right, and it dealing with the objection based on the application of the rule of res judicata, the aspect the matter has no doubt be borne in mind. 9. But is the rule of res judicata merely technical rule, or it is based on high public policy? If the rule of res judicata itself embodies a principle of public policy, which in turn is an essential part of the rule of law, then the objection that the rule cannot be invoked where the fundamental rights are in question may lose such of its validity. Now, the rule of res judicata, as indicated in Section 11 of the Code of Civil Procedure, has no doubt some technical aspects. For the instance of the rule of constructive res judicata may be said to have technical, but the basis on which the said rule rests is founded on considerations of public policy. It is in the interest of the public at large that the finality should attach to the binding decisions pronounced by court of competent jurisdiction. And it is also in the public interest that individuals should not be vexed twice over the same kind of litigation. If these two principles form the foundation of the general rule of res judicata, they cannot be treated to irrelevant or inadmissible even in dealing the fundamental rights in the petition filed under Article 32. Next, my lord. In considering the essential elements of res judicata, one inevitably harks back on the judgment of Sir William B. Hill, such and such. From the variety of the cases, relatively judgment being given evidence in civil suits, these two deductions seem to follow generally true. First, that the judgment of a court of concurrent jurisdiction directly upon the point it as a plea, a bar, or evidence conclusive between the same parties upon the same matter directly in question in another court. Secondly, that the judgment of a court of exclusive jurisdiction directly upon the point is in like manner conclusive upon the same matter between the same parties coming incidentally in question another court for a different purpose has been observed by the Halsbury. The court of doctrine of res judicata is not a technical doctrine applicable only to the records. It's a fundamental doctrine of all courts that there must be an end of litigation. But thereafter, it has been quoted from the Halsbury, the res judicata, where the res judicata has been, principal res judicata has been defined in the Halsbury of India and in the London, and all these, my lord. My lord, by citing this judgment, I would beseech your lordship to say that the litigation has to end somewhere. It is, my lord, if your lordship is, if not, the writ petition, if not filed today, my lord, I am taking a hyper technical situation. If there is no writ petition as of now, they will file another 173. There will be.
Tell me one thing, how come this numbering is there like this?
Which one, my lord?
You come to the previous, you started from paragraph 9.
9.
Thereafter paragraph 10.
Yes.
Huh.
I have not seen this, my lord. But kindly see, my lord, the page number in the top left side, top left, it's 6, then 7. Why, my lord, is it written that SCC Online Web Edition? Such and such? 6. Thereafter page 7. The next page showing page 7.
7, 8 only.
In mids there are not.
No, paragraphs maybe.
Your lordship is saying that after paragraph 10, how the 18 came. But the pages are 6 and 7. Continuous.
No, and there is a sequence of chronology also when when you are placing the paragraph.
But paragraph number may be different.
Yes.
To end here or to continue.
You will not complete today.
If your lordship please explain, I have to complete. Lord.
No, my pleasing is obviously subject to the energy available with the councils. Na? Then day after tomorrow you continue.
Mal.
Don't take a long date, sir.
Even tomorrow, if it suits your lordship. Lord.
Tomorrow I want to continue with the motions till the end. Day after tomorrow, sir, this will continue. Thursday. Same time, 4 o'clock, 10-15 minutes here and there it will take. Mr. Shamanto, learned advocate, appearing on behalf of the state, intends to continue with his argument. Learned advocate aid for the petitioner is present. The added respondent appears.
Respondent number 10. He was there all along.
The respondent number 10 appears in person. Full stop. Let the hearing of the writ petition continue on 24th of July 2025 at 4 p.m. And the same will appear when it will appear under the same heading. When it will appear under the same heading. In person. এটা একটু গুছিয়ে রাখবেন কোথায় গেল আনন্দি কোথায় গেল
Standing on our face.
হ্যাঁ
Standing on our face.
ঘুম এসে গেছিল